Please hand over the slips apart from hearing.
My lord,
My lord, one matter, my lord.
one
My lord, I'm taking my lord, your losses kind leave. It is a hearing matter under Order 7, Rule 11. After 10 years at the peremptory stage, plain time rejected in view of Rajesh Mitra. 2G. Now, my lord, all courts are staring at me. What is happening in the High Court about this matter? They are waiting for this, my lord. It will take a few minutes for your lordship, my lord. I've prepared the paperwork. Everything is ready.
my lord.
Milord would remember regarding this matter of mining. The mine was closed, citing the 2013 rules.
Please
but
hand over the applications and order for turns first. Then we'll hear the other. Yes, applications and order for turns, please.
not applications.
Applications
But
and order for turns.
I'm deeply
Need not mention. Yes. Extension also. Extension to be mentioned. Application order for turn. Small matters.
My lord, I have an application for amendment, my lord.
Application you need not mention it.
Application.
Just hand over.
Milord, may just for
Yes, we'll come back.
And number
So applications and order for turns are over. Will
Milord,
not take up any further application order for turn mentioning today. Yes.
application, Milord, but Milord would remember your lordship had told me to come back this week. The mine had been closed under 2013 rules.
They appear in the list. Yes.
I'm deeply obliged.
My lord, contempt application, my lord, the urgency.
It's an application.
My lord, your lordship has directed to for payment of alimony.
No, it's an application. Hand over.
And my lord, urgency, urgency, my
No
lord,
urgency.
stop.
Contempt letter. Yes.
Lordship,
We cannot, because what's the use? We cannot take up these matters even. On Thursdays, we are taking up hearing matters. After we dispose of some hearing matters, we'll definitely add. Now, what's the use of ornamenting the list by adding them? Yes, any other mentioning apart from hearing?
tribunal matter, my
No, we told you no. Yes, call on the list.
My lord, admission of hearing, my lord.
No further hearing.
Lordship, I am
No further mentioning.
Lordship playing for
Call on the list. No further mentioning. Yes.
playing for leave to file without certified.
One second. Lift the deed. Lift the deed.
Lordship execution is. Your
Lordship, these are lovers.
No further mentioning. We told you repeatedly to hand over applications and order for turns. If you have not listened to us, forget it.
My case is lordship hearing matters.
Your case is not special. Please call on the list.
Is going on.
Please call on the list.
Lordship, this is a appeal under Lordship Enemy Property Act.
রাখবেন না? Act taken. Accordingly, WPLRT number 6 of 2014 is allowed on contest, thereby setting aside the impugned judgment dated November 12, 2013, passed by the first bench of the West Bengal Land Reforms and Tenancy Tribunal in OA number such and such. It is hereby held that the subject property is not a ticket tenancy within the contemplation of any of the ticket tenancy acts, whether 1949, 81, or 2001. Can to accordingly dispose of, no orders to cause urgent certificate. Yes.
Undertaking being না 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 কি আছে এখানে হারাবার কিছু নেই লস কেস
Call. There you go. আপনি করুন ততক্ষণ
Item number 2, my lord, I'm appealing for the appellant.
mention. Yes.
Yes, my lord, to be mentioned, my lord, your lordship directed us to, my lord, the client to file an undertaking. But my lord, if your lordship kindly takes your lordship's order on 19th November.
Your client was to file undertaking.
Yes, my lord.
Yes, you wanted a fresh hearing, probably.
No, yes. My lord,
But yes, what is the undertaking?
my lord, paragraph 6 and 7. My lord, paragraph 6, my lord, we have specifically, my lord, submitted that there is no objection certificate from the other lawyer. So, my lord, if an undertaking in respect to a notary, my lord, if your lordship accepts it.
So, have you filed this no objection certificate?
No, my lord, that we have stated on last occasion, and no objection
Then
certificate.
we'll dismiss we will dismiss the appeal. Because order for Rule 11, Justice Tandon's bench had held that.
That has been.
No, we'll dismiss the appeal outright.
Well, only one, well, if your lordship allows, well, an undertaking in a, they have done in a.
How can you take an
Yeah,
undertaking?
your lordship cannot.
Without the advocate on record.
That I know.
We gave you
That-
time for that.
Well, because he could not get, and bar council complaint has been. I'm not going on that, my lord.
No, then you know, Mr. Chakrabarty, you have to only write to them to the previous advocate by registered post with AD, and if it comes back, you can take a leave under order from us.
My lord,
Why didn't you advise your client accordingly? We gave you time for that only. 19th of November, we gave you time to take no objection. If the advocate does not give no objection, the method should be known by you by now, Mr. Chakrabarty.
Well,
You have to simply write registered post with AD, you file that, and along with that, if it's served properly, if it does not give a notice, we can grant you leave to appear in the matter. We'll cancel that appearance. You have not done it.
It was done in a different way, my lord. So,
What different way?
they have filed a speed post. This is, but not to the lawyer, to the bar council.
This matter has a short checkered history. Full stop. By a previous order, comma, the previous order, comma, dated November 22, 2024, comma, a coordinate bench had observed that the court is not inclined to admit the appeal as there is no substantial question of law involved, but merely on the submission of learned counsel for the appellant that the appellants may be permitted to remain in occupation for a brief period of time, comma, a notice was directed to be given to the respondent. Full stop. Despite such notice having been given and the respondent appearing, comma, the appellant remained unrepresented on December 17, 2024, when the matter appeared before the same coordinate bench. Full stop. Next para. Thereafter, comma, the matter came before us on November 19, 2025, comma, when taking note of the fact that the previous coordinate bench had merely posted it for further orders on the prayer of the appellants to file an undertaking, comma, to leave the premises, comma. We had deprecated the sharp practice adopted by the appellants in seeking a fresh hearing under Order 41 Rule 11 of the Code of Civil Procedure, comma, since the coordinate bench had all but dismissed the appeal under the said provision, but merely granted the grace to the appellant to have some time to leave the premises. Full stop. We had further recorded in our order dated November 19, 2025 that learned counsel appearing on that day for the appellants had not yet obtained any no objection certificate from the present learned advocate for the appellants. Full stop. Next para. The procedure in law is well known. Full stop. The said learned advocate for the appellants ought to have been contacted by the appellants seeking a no objection, and in the event no response came thereto despite such service, comma, the court always had the power to cancel the previous vakalatam and permit the present advocates to appear. Full stop. However, comma, even today, comma, we find that no such effort has been taken out by the appellants, comma, thereby clearly showing the malafidez of the appellants in stalling time, in buying time merely to protract the execution of the valid degree obtained against the said appellants. Full stop. In such view of the matter, comma, we formally observe that SAT 124 of 2023 is dismissed under Order 41 Rule 11 of the Code of Civil Procedure in view of no substantial question of law being involved. Full stop. Consequentially, Can 1 of 2023 is dismissed as well. Full stop. It is expected that the execution, you have already executed. Since it is we are informed that execution has taken place. You have taken possession.
No. Proceeding is going on.
That is what we are asking you. Since we are informed that the execution case has already been taken out, comma, the said proceeding shall be concluded as expeditiously as possible. Next. Thank you.
My lord, may I seek indulgence to appear online, lordship, for the appellant?
Yes.
Lordship, in this matter, on 6th of August, there is an order for filing some notices within a time frame, lordship, that has been done. So, lordship, I seek such order the observation that it is complied, because otherwise the department is saying for filing the paper book, lordship, there is some difficulty arising, lordship.
So the office report says, Ms. Gututia, that the service return has been received, which reveals that the notice was marked as unserved.
Lordship.
So, therefore,
So, lordship, I filed within time as directed in last order. Lordship,
no,
kindly
not a
see.
question of your filing. You have filed within time, but it has not been served, so you have to file afresh.
Lordship.
And it can also will permit you to put in further postal cost for service of notice, as well as to serve directly by post,
Lordship.
registered post with AD, and the office will seek a further report from the office after a month.
Lordship. And may I file the paper book also after
Paper
4
books,
weeks?
if those are prepared, please file. The records have arrived.
Lordship. LCR have come.
Very well. Learned counsel, you are for the appellant, must be.
Lordship. Lordship.
Learned counsel for the appellant submits that the trial court records have already arrived and the paper books have been prepared. Full stop. Accordingly, on the prayer of the appellant, we permit the learned advocate for the appellant to file the requisite number of paper books in the department. Full stop. Next
Within
para,
2 weeks.
insofar as service on the respondent is concerned, the office report dated November 18, 2025 indicates that the notice sought to be served on the respondent returned as unserved. Full stop. Accordingly, the appellant shall put in fresh postal costs as well as other requisites for service of notice of the appeal on the respondent within a week from date. Full stop. Over and above, the respondent is also permitted to serve notice of hearing of the appeal directly on the respondent by registered post with acknowledgement due and intimate the outcome of the same to the office. Full stop. The office shall file a further revised report in that regard, highlighting as to whether service has been effected on the respondent by either mode, within a month from date. Full stop. The matter shall next be listed on January 6, 2025.
Lordship, instead of respondent, appellant will go, Lordship. Lordship directed the respondent to serve again. So appellant will be there. It's slightly.
Respondent ke serve karte hoje. No, to be served on the respondent's website.
Appellant will be written. When the draft will come to Lordship, it will be clear.
Well, yes, next.
Grateful, Lordship.
Thank you.
Lordship, item number 4, Your Lordship, I am for the appellant. The matter has come at my instance, Your Lordship. Kindly, Your Lordship, sees paragraph 14 of this order. The messenger cost has been made, but it was not within the 7 days time which was a mandate under para 14 of Your Lordship.
Trial court records. We'll accept that and that the.
Yes, my lord, I
You are appealing for
I
this.
have also filed an application
For?
For some.
I'm led by Mr. Dhar, Your Lord.
Filed an application for what?
Application for further order, my.
What order? Further order means?
Your lordship kindly passed an order that appellant should pay the awarded amount.
We'll direct that application to come in the list tomorrow.
Yes, ma'am.
The learned advocate for the appellant seeks acceptance of the delayed deposit of special messenger costs. Full stop. On oral prayer of the appellant, we condone the delay in depositing the special messenger cost for bringing the trial court records and accept such costs. Full stop. The office shall take immediate steps for to ensure that the trial court records are brought accordingly. Full stop. The pending applications, if any, be listed tomorrow under the appropriate heading. Kalke application is application. Give copies if you have not given.
No. Right now, I got the copy.
Appearances. Please give your appearances the other side also. Yes.
This appeal should be maybe dismissed, my lord, for non-prosecution as the dispute has been settled out of court between the parties.
You are for the appellant?
My
Learned counsel for the appellant submits that the matter has been settled out of court between the parties. Full stop. Accordingly, ACT 217 of 2024. Any connected application?
No,
Is dismissed for non-prosecution without any order as to cost.
I'm great.
Thank you.
Item number 6. My lord, item number 6.
Release.
Release.
Shoini Chakraborty.
Shoini Chakraborty is appeared.
In view of the relatives of one of us within bracket Bhattacharya Ji appearing for one of the parties in the matter, let the matter stand released from our list with liberty to the parties to seek an assignment before a different bench from the Honorable the Acting Chief Justice. Thank you.
Item number 7. Number 7 also same.
Same order. Same order.
Item number 8.
Yes, my lord. I'm for the appellant, my lord.
Was it appearance to be mentioned? Can you tell us?
My lord, I think the mediation failed. I think that is why the matter has come up.
Oh, there's a problem here. Justice Showman's division bench,
Yes, my lord.
while sending it for mediation, had observed that the appeal is disposed of,
Yes,
and
my
then
lord.
it was sent. But
Yes.
since mediation has failed,
Hmm.
we took advice from the Honorable Chief Justice. So it's better because Justice Sinara is still there.
Yes, my lord.
So we sought the option whether we can do anything or we should refer it. The Honorable Acting Chief Justice has assured us that we'll just release it, a bench to be constituted with Justice Sinara, and that will be done immediately. We are passing that order. Uh, a peculiar issue has arisen in the present matter. First up, by an order dated September 3, 2025, the appeal and a coordinate bench had disposed of the appeal as well as the application while, however, sending the matter for mediation. For next para, subsequently mediation having failed, the matter has returned to this court. However, due to the said observation that the appeal and the application were disposed of, there is an impediment in the matter being taken up by this bench. Next para, it is observed that out of the two honorable judges of this court who comprised the coordinate bench which disposed of the appeal, one learned judge is still available. Accordingly, the matter be sent to the Honorable the Acting Chief Justice for constitution of a bench comprised inter alia of Justice Apurvo Sinhare, for the purpose of modification of the order dated September 3, 2025, and passing necessary directions for the appeal to be heard on merits. এটা চিফ জাস্টিসের কাছে চলে যাবে, মানে ইয়ের জন্য, অ্যাসাইনমেন্টের জন্য।
Item number 9.
I beg to appear for the appellant petitioner. Lord, I believe there is a defect. Lord, if I'm not wrong, Lord, the trial court
Out of time is stated.
But,
Some other defect also.
application for condemnation of delay has been filed.
That's
Lord, it is
acceptable.
can 1. Lord,
Let us see the other. Misappellate court stayed the operation of an injunction order. This is revisable. Office report is correct. The present appeal has been preferred against an order of the appellate court staying the operation of an injunction order passed by the trial court. Since no second appeal under order 43 is available under the Code of Civil Procedure, and in view of the order of stay of operation of an injunction order is otherwise not appealable, SAT 09 of 2004 along with Can 1 of 2024 are dismissed as not maintainable, with liberty to the appellant to prefer an appropriate challenge before the appropriate court against the self-same order. Leave is granted to the learned advocate record for the appellant to take back the certified copy of the impugned order upon furnishing a photocopy there in the department.
I'm embarrassed, my Lord. Deeply embarrassed.
Can act it again.
There are, my Lord, there are two applications. One was
Can
for
can
the
can 1 bolechi, can 2 koro, and can 2. Thank you.
deeply
Please give your appearances in the previous.
Lordship, on behalf of the petitioner and the learned senior advocate on record is another court conducting a matter. So
We'll
praying,
dismiss or default. Sorry, no.
so praying for a passover, sir.
No refuse. You move the matter. Move the matter.
My lord, I'm new here. Senior advocate is
How
conducting.
new?
Please,
How new? How new?
8 months, sir.
8 months sufficient.
New in High Court, sir. Actually, 8 months I'm practicing the
God.
district.
Oh, what? District courts are better than us. They know the law better.
My lord, please,
Doesn't-
a short passover, my lord.
No possible. Start the matter. Where is the brief?
With senior advocate, sir, my lord.
Tell your senior that you have dismissed or default. An adjournment is sought for. However, we find that there are certain deficiencies, certain defects in the appeal. Full stop. The appellant is directed to cure such defects within a week from date and serve a copy of Can 1 of 2024 on the respondents, indicating that the matter shall be listed under the same heading in the monthly list of January 2026. In the meantime, correct the defects. Ask your senior to correct the defects. Even if your senior was here, this would be the order. And serve a copy of the condonation application on the other side.
Oblige, my
After an affidavit of service to that effect shall be filed on the returnable date. Next.
Item number 11.
11, Mr. Roy.
Your Lordship, tomorrow.
No time. Order for no time. We are not being able to add matters, so no time in any of these matters.
There is Section 5 application, my lord.
Section 5 served.
Yes, we have served, my lord. Evidence services are this. You
Coming.
have served. It's
Very. So what is the Section 5 first? Let us see that.
32 days delay in receipt of
How many?
32 days delay.
What is the reason, Mr.
Is it well the wrong calculation is the advocate's records? It is the
Acha, it has been served.
yes. I'll
On the prayer of learned counsel for the appellant, leave is granted to the appellant to file the affidavit of service during the course of the day. First of next para, upon a perusal of Can 2 of 2025, we find that sufficient explanation for the delay in preferring the appeal has been furnished. Accordingly, Can 2 of 2025 is allowed, thereby condoning the delay in filing SAT 101 of 2025. First of, the appeal is now taken up for hearing under order 41 rule 11 of the Code of Civil. Remove it.
plaintiff is the appellant before lordship. Suit for declaration of title and recovery of position in respect
Both courts.
both the courts.
Declaration
But both the courts held
differently.
but conclusion is the same. Now, my lord, the appellate court suit for declaration and injunction and for recovery of position. Recovery of position is set of the one scheduled property. There are three scheduled properties.
Declaration of your ownership
Declaration of my ownership.
and recovery of portion from alleged licensee.
Is a forcefully entered into trespasser. In respect of the C scheduled property. And the B scheduled property is the comprising of the vacant portion which is still in my occupation. A schedule comprises of B and C. C from I have been evicted. B
So
is
title in respect of A
recovery from C.
and B what? Injunction? Nothing.
Yes.
Forget B. Yes.
Now, my lord, it is a property belongs to a trust. Private trust. From the trust.
Or you the owner?
The trust is transferred the property for the benefit of the debtor, though the permission was sought for from the district judge and ceremony was allowed. Though it is not in view of Section 1 of the Trust Act, your lordship find the private religious trust does not come within the purview of the Trust Act. So 34 permission is immaterial whether it is granted or not, but for the benefit of the debtor. Now I purchase the property, demarcated property from the erstwhile Sevaites. That is admitted. Now, my lord, after purchasing the same, the defendants came into the picture and forcefully evicted me from C scheduled property.
Why did you lose?
Because, my lord, the entire plot of land is 1.26 acres, out of which I am claiming, or the debtor's right was limited to 34 decibel of land, out of which 4 cutters of land was transferred by a demarcation by the Sevaites. The learned trial court is of the opinion.
No, 4 cutter transfer means 34 decimals, you say.
34 decibel belongs to the debtor. It is a trust property, belongs to the debtor.
So you are not the owner of the entire A.
No, A schedule property is the 34 4 cutters of land.
A schedule is 4 cutter.
34 is the total land belongs to the debtor. And the area of the total plot is 1.26. May I clear to your lordship?
No, total. We don't understand. I mean, you are giving 3 numbers.
Yes.
So how do you tally those?
Yes. The entire plot of land
If
consists
the
of.
debtor was not the owner of the entire A, then how can you
No,
purchase?
entire A is mine, which I have purchased, demarcated from the
Did-
debtor.
That is 4 cutter.
That is 4 cutter.
A is 4 cutter.
And
So originally 1.2 and
1.26 acres is the original plot of land.
the owners or the sole owner demarcated.
No,
And
my
so
lord, the debtor's name was there in a 34 decibel of land.
how could you purchase?
That is precisely, my lord.
Rightly headed. Could not
Two things,
purchase.
my lord. Whether it is barred under Section 34, if it is barred under Section 34, my lord.
Why do you say Section 34? You don't even have title of, because all the co-owners have title over the entire property.
No, the 34 decimal belongs to the debtor.
It cannot be demarcated. Could not
Yes.
be demarcated.
So even if, my lord, the co-share can transfer, if I
the deity can be a term to be a
Transfer
portion.
can transfer is share.
Yes,
How can I obtain an eviction unless all the co-owners are joined?
precisely, my lord, the eviction was on that score, my lord. If the person defendant,
Declaration was given. Declaration.
no,
You say that even if eviction was not granted,
granted I have joint position.
so you are co-owner at least. The deity is
At least
deity was
the deity's title did not be disputed.
but the title did sold a demarcated portion.
Yes.
You say the effect of that should be construed to be the transfer of shares.
Just
How did the appeal court deal with it?
Now,
Why
the-
differently?
appeal court is of the opinion if your lordship can transfer the appeal court judgment once. I draw your lordship attention to internal page.
What you said is that how the trial court proceeded.
Yes, this is the trial court.
Appeal.
Now, my lord, now I have got the brief and I have the appellate court.
You have prepared the appellate court. You have not prepared.
No, I have prepared, my lord, but not to that sense, my lord.
Oh, you will
Yeah.
never get satisfaction that I am fully prepared in any matter. Did you ever have that satisfaction when going to an examination hall? You never have that. Let us get ready together. Yeah.
Now, if your lordship can turn to
Yes.
the internal page 9 of the appeal court judgment.
Yes. After the first flash is over. It starts with at the first flash.
Oh, yes.
So therefore, you are on the second flash. Yes. What is the finding?
Now the T is first class minor T. So going on going through the minor paragraph 12.
Yes.
Deed sale marks as exhibit 1, exhibit in favor of the appellant plaintiff. Minor got it. It is relevant that the piece and parcel of Bastugal measures char cutter or little more together with correct pillars or concrete pillars in 4. I have to reduce my speed.
Yes, you have to control that.
4 cutters
And you have to complete your sentences, Mr. Rai.
Yes, sir.
Only these two are the.
It is relevant that the piece and parcel of Bastu land measuring 4 cutters a little or less together with concrete pillar in 4 corners thereon, situated at Srinagar, PS such and such, my lord, skipping over the rest portion, within the territory of Rajpur Sonapur municipality was transferred in favor of the appellant plaintiff. The sketch map marked with the red border attached with the deed reflected 4 cutters of land in the aforementioned plot, and the numbers were transferred in favor of the plaintiff appellant. So it is both the case, my lord. There is no dispute. Now, my lord, can I turn to the portion that is at page internal page 11. Last paragraph, paragraph 18.
It was never held that the
Deity has no
defendants right was never established.
defendants of claim pursuant to deed, but it does not disclose any of the judgment by both the courts below that yes, their deed is valid. But my suit was dismissed on the ground that
Their deed is subsequent to yours.
yes, these are subsequently me. They are claiming that it is a secular property, but those are not been adjudicated. I've tried lordship.
Very well.
So that portion, if your lordship can turn to page internal page 11, paragraph 18.
No, paragraph 16 it says dissimilarities in description of plot appearing schedules of the deed marked as exhibit 1 and plaint.
Yes.
So there is a discrepancy in the
There is
schedules.
a construction. In my plaint, I have category mentioned 4 cutters of land upon which there was a construction made by me. But the deed does not say about any construction of a building.
You say after purchase you construct.
Yes,
Well,
that is it.
let us come to para 18.
Yes. Now the para 18, my lord, but the permission which was granted has been disbelieved by the learned court of appeal below that the PW1 admitted during his cross-examination that Shevai Pranab Prasad Roy expired in the year 2000. According to the petition submitted in miscase number, that is the permission sought for by the Shevais, filed with learned district Alipur, that Anil Krishna Roy had no male issue for which her female legal heirs were not in a position to act as Shevais in terms of the state of Pranama. The cost title of the said petition that the learned legal petition that the legal heirs of Pratibha Charan Roy was one of the opposite parties. Nothing is found either in the plaint of this case or in the petition filed under miscase number such and such about the whereabouts of details of another Shevai Pranab Prasad Roy or his legal heirs. Exhibit 1 is executed on the basis of the permission granted by the learned district judge at Alipur such and such. However, it is not clear whether Tarakeshwara was at all entitled to file application under section 34 or 36 of the Indian Trust Act without submitting any details about the legal heirs of the other Shevai Pranab Prasad Roy, if any. As it apparent from the evidence of appellant plaintiff, the Pranab Prasad expired in the year 2000. The silence on the point of legal heirs of Pranab Prasad Roy itself amounts to violation of terms of the deed of trust, which mother instrument of all subsequent transfer related to with the suit dug. So this was the consideration before the appellate court for holding that the transfer deed executed in favor of the appellate is void. Now, there are two things I have to argue before your lordship. Whether a Shebite can represent the deity. It is the deity's property. It is Shebite cannot be termed to a property. Deity can be represented by this Shebite. In the deed itself, my lord will not find that minimum these numbers of Shebite will be participated in that for the purpose of taking any decision. So, miscase whether the order passed in the miscase whether any bearing so far the transfer is concerned, unless and until it appears for the court below, yes, it is to the detrimental to the interest of the deity. This transfer has been effected to the detrimental interest of the deity. Merely whether there is irregularities or infirmities in the passing of the miscase order, that cannot regulate my transaction, because this miscase under section 36 or 34 does not have any bearing so far my transfer is concerned, because it is a private trust and Trust Act does not have any application at all.
And where is that trial court's
Yes, my lord.
that finding which you said? It was filed later.
Yes, subsequently, my lord, it was filed. And file করেছেন তো? হ্যাঁ। Yes, sir, the judgment degree filed, my lord. 11th.
Yes, yes, we have it.
Yes. Your lordship, I will turn to
They have produced the title deeds.
yes, yes. But it was they produced the title deeds that some of that is why precisely, my lord, they said this is a secular property out of 1.26 acres. My lord, if a lordship
You produced the Orphanama
yes, Orphanama was produced.
and permission also.
Permission along with the resolutions of the Shevites. In the deed itself, it was incorporated on which day the Shevites have decided on which.
Who transferred to them? Who transferred to them? One of the Shevites.
No, no, no. It is according to them that some portion belongs to the as a secular property of Rise. And from them they have purchased the property. There is no dispute regarding the title because while a 34 decimal out of 1.26. Now the question is whether this 36
if you are co-owners, then they are also co-owners.
Co-owners. Even if my lord, then my lord, my title cannot be over it. I am entitled to joint possession as pleased.
But
I could have
your plaint as framed, the suit as framed is then improper. You have
Yes.
framed absolute title.
Yes, I
the
proceeded
court
by on
find
the
such
basis
degree?
of the deed itself, where it give me a particular portion of the property. Now, my lord, the judgment which has been delivered by my lord Justice Rai, as his lordship, there was a Supreme Court as a declaration, and I am entitled to joint possession, which is delivered. If a joint possession I am entitled to get, I am not entitled to get a degree of eviction. Whether it decided me to pray for joint possession of the property in question.
This second appeal will be heard on the following substantial question of law. 1. Whether the learned first appellate court substantially erred in law in holding that the transfer by the deity through its Shebite in favor of the appellant was bad in law in view of the permission granted for such transfer under sections 34/36 of the Indian Trust Act was vitiated, comma, in view of the property being a private Devottar property, comma, there was no, it was irrelevant, comma, there was it was irrelevant as to whether any permission is obtained under the said provision. Roman 2, whether the learned first appellate court substantially erred in law in holding that there was a discrepancy in the description of the property between the schedules of the transfer deed in favor of the appellant and the plaintiff, comma, inasmuch as the boundaries and other description of the property remains the same, comma, barring a construction which has subsequently been made on the property, comma, as such, there being no such distinction between the two properties. Roman 3, whether, comma, even if the deity stroke transferor of the plaintiff stroke appellant was only a co-owner in respect of the total property, comma, the courts below substantially erred in law in not granting declaration of the title of the appellant in respect of the property, at least as a co-sharer in respect of a particular share in the property which belonged to the deity. Any interim?
Yes, my lord, I filed an application, my lord.
The appellant shall serve serve copies of Can 1 of 2025 on the respondent, indicating that the matter shall be listed before the appropriate learned single judge having determination after the timelines for filing of affidavits are over. Full stop. The respondent shall file their affidavit in opposition to the application within 3 weeks from date. Full stop. Reply, if any, shall be filed within 1 week thereafter. The respondents and their men and agents shall remain restrained by an order of injunction from changing the status quo in respect of the suit property and or creating any third party interest in respect thereof during pendency of the application.
Grateful to your lordship. I am filing by evidence service. It is there,
The
ma'am.
appellant shall file
Yeah, it is in the first line. You have my lord has already indicated.
no.
Evidence.
We are directing to serve again.
Yes.
The second application. The appellant shall file an affidavit of service to that effect on the returnable date before the learned signature. এটা ঢোকালে affidavit of service ঢোকালে
দিদি আপনাকে খেলা করে আমি এক্ষুনি দিয়ে যাচ্ছি।
next.
I am for the plaintiff appellant.
Yes.
Now it is found that there is delay. But my lord, according to my calculation, it is within time.
You have
Because
not filed any section 5.
no,
Achha, you say it is within time.
my lord,
We'll just check up.
check up my lord whether the
Yes, yes,
stamp
immediately.
reporter's report and my calculation.
Stamp reporter says how many days delay? No.
দেখাটা আছে।
Yes.
If your lordship can it
No, it says deficit court fees. Oh, deficit court fees have been deposited beyond time.
that yes.
It does not say list কি অ্যাপেয়ার করছে ये বলো out of time defective কেন দিয়েছেন?
If it is only for deficit court fees, that is a different thing.
এটা কেন দিয়েছে স্ট্যাম্প রিপোর্টে? আর পরের রিপোর্ট আছে কিছু? না না পরের this deposit was made within time.
No.
We'll accept that and hear you.
No.
Yes, the deficit, the delay in depositing deficit court fees is condoned, and such deposits are accepted. Full stop. The appeal is accordingly treated to be in form. Full stop. The same is taken up for hearing under order for Rule 11 of the Code of Civil Procedure. Yes, Mr. There is no caveat.
Yes. Well, suit is for accounts. That is not, I am a railway contractor. I have done certain job. My lord, I have not satisfied with the payment. I filed the suit for recovery of money.
Recovery of money and accounts.
My lord. My lord, it is judgment of affirmance. Trial court dismissed my suit. But the appellate court, if your lordships, my lord, kindly see the judgment. It is 43 pages judgment.
43?
43 pages only. But my lord, so far the findings are concerned, the dealings is concerned, my lord, I have not got anything. My lord, if your lordship
Not
start,
got anything means there is nothing.
everything is set out. Everything is set out. My lord, page
Achha, what
one,
the civil judge held and all these things, yes.
my lord, the grounds of the memorandum appeal has been narrated from page 4. My lord,
Yes.
still
Submitted.
8, page till 8. Then my lord, point for consideration, hence this appeal point for that has been stated. Then reasons with decision with reasons needs my lord plain case. Plain case has been narrated. It up to then my lord schedule of the plaint has been. Then my lord, the defense case is as page for 26 after schedule C defense case it starts. Then
No, the reasoning starts from page 41. Bottom, exhibit 1 clearly shows.
Page 41.
After those, the last paragraph, exhibit 1 clearly shows.
Exhibit clearly shows that no supplementary item of work for any non-tendered item will be entertained without any prior written. This is my lord relating to only the additional works. But
you asked for main work as well as additional work.
Yes. So far the main work, my main contention, my lord, if my lord will find it.
So what was the, let us look into the trial court judgment also, Mr. Mathur.
Yes. My lord, I am
could not prove your.
From the appeal court's judgment, I am showing one thing, my lord. What I am relying,
Yes.
that I am showing to your lordships. My lord, kindly come to page 29. Issue number exhibit 5 and 6.
Yes.
A copy, exhibit 5 is a copy of the letter dated 13th May 2008 given by the superintending engineer such and such, and exhibit C is the GO dated such and such relating to compensation to certain extent may be allowed for recent unusual rise in price or such and such items. Well, these two documents has not been properly considered. Well, court has says that these I am not entitled to get any benefit from these exhibits.
No, but what about the main amount, main claim? How did the trial court deal with that? Did you fail to prove those? Did you produce
well,
the bills and everything? Work
Well,
orders?
these I am entitled to get my lord compensation because of unusual rise in price.
You claimed only that
Yes, in this case, my lord, only that, and the supplementary works.
and the supplementary. So the main claim, the main work,
I have got something.
original price was that was the main crux
Yes,
of the case.
Yes. Therefore, my lord, the whether
Trial court, what did the trial court do? Not
well, trial court has says, my lord, that I am not entitled to as per this GO.
Can you please show us the finding on that?
Yes, ma'am. Issue number 5.
No, page 15, internal page 15 of the trial court. If you come to the last, say about 10 lines from the bottom, these defendants, internal page 15 of the trial court. These defendants have further contended that as per GO number.
Yes, as per GO.
Please read that portion, Mr. Mahathir. We'll just clarify.
As per GO number such and such dated 12th of September 2008, department the calculation for determination of quantum of compensation in respect of item work involving steel, cement, brick, stone, materials, etc. is different from the proposed percentage of quota quoted by the plaintiff. As per GO, quantity of different materials like stone, sand, cement, steel involved in the work should be determined first. Well, this is memo dated 12th of September 2008. And what I am relying.
Yes, exhibit 6 is that.
Exhibit 5 is also there, my lord.
Have you got copies of those? 5 and 6?
Yes.
Let us see those.
Exhibit 5 and exhibit 6. I think এখানে করা আছে। করা আছে।
Just shows 5 and 6.
5 and 6. খুলে মধ্যে আছে। তুমি দেখো।
But what about this, you having failed to submit documents to the department relating purchase of different building materials, those materials? You have to prove that in the first place. Trial court also says,
well, it is not disputed that I have constructed the building. Therefore, certainly I have purchased. But the rate is required to be considered according to this GO. But court has not considered that.
This second appeal will be heard on the following substantial questions of law. 1, Roman 1, whether the first appellate, whether the judgment and decree of the first appellate court are a proper judgment of affirmance inasmuch as the lion's share of the said judgment is devoted to the narration of the respective cases of the parties and the trial court's judgment, without a comprehensive assessment of the materials on record. Roman 2, whether both the courts below failed to take into consideration the proper purport of Exhibit 5, a corrigendum letter dated May 13, 2008, and Exhibit 6, a government order GO capital dated September 12, 2008, by virtue of which the plaintiff stroke appellant was entitled to payment at enhanced rates for materials supplied by the appellant, in view of the work having been done by the appellant having not been disputed by the defendant respondent. Next ground, whether the courts below acted substantial error in law in coming to the perverse finding that the appellant has failed to prove its case, comma, by overlooking the substantive material, comma, including the respective work orders and the government orders, comma, having been produced by the appellant to substantiate its case. Any interim order? No question of it.
No,
No
sir.
question of it.
Well, so far the exhibit 6 in concern, well, they have also produced the same document which is exhibit E.
Yes, but
Ma'am,
those are exhibits, so no difficult. The appellant shall put in postal costs and requisites for service of notice of the appeal on the respondent respondents within a week from date. The appellant shall also prepare the trial court record shall be brought by special messenger at the cost of the appellant to be deposited within a week from date. First of the appellant shall prepare and file the requisite number of informal paper books without comparing with the records within 6 weeks from the date of service of notice of the arrival of the trial court records on the learned counsel for the learned advocate for the appellant. Liberty to the parties to mention the appeal before the appropriate learned single judge, then having determination for inclusion of the appeal for hearing. As and when the same is ready for him.
I'm good.
Consider for the document.
Done for the appellant. Section 5 application, Lord, the defect, Lord, which has been pointed out by the stamp reporter. First, Lord, the deficit court fee has been paid. Now, Lord, regarding the filing of the appeal by the son instead of father, Lord, in the application we have given the, Lord, the power of attorney. So, Lord, that defect cured.
Achha.
So far as regards,
But the appellant, the name of the appellant is the father's name. Vokalatnama filed.
Vokalatnama, yes.
No,
through Milord,
Vokalatnama.
Through as a power of attorney.
Power of attorney you have filed.
Yes, already filed, Milord, in respect to Milord the application.
Achha.
Can 1, Milord, while filing can 1.
Court fee have
deficit court fee, Milord, already paid. Regarding the quantification of delay, Milord, my junior has made a mistake. It should have been 71 days.
So
it's written, Milord, 40, Milord. Kindly allow me, Milord, to correct, Milord, my advocate on record to correct that.
Have you served copy?
No, Milord, first time.
Achha, very well. Insofar as the defects pointed out by the additional stamp reporter are concerned, comma, the deficit court fees have already been paid and are accepted. Full stop. Secondly, comma, regarding the Vakalatnama having allegedly been executed by a stranger, comma, learned counsel for the appellant points out that the Vakalatnama has been executed by the son of the appellant along and filed along with a power of attorney indicating that the said son is the constituted attorney of the appellant. Accordingly, the said defect also stands cured. Insofar as the application for condonation of delay is concerned, comma, on the prayer of learned counsel for the appellant, comma, leave is granted to the appellant to file a supplementary affidavit incorporating necessary omitted averments. Next para, the appellant shall serve copies of the application as well as an advance copy of the supplementary affidavit on the respondents, indicating that the application that the matter shall be listed under the same heading on December 15, 2025, when an affidavit of service to that effect shall be filed by the appellant. Great, thank you.
Item number 14.
Lawsuit, I am appearing with the plenty of villain lawsuit.
Respondent.
I'm for the respondent.
Yes.
And Vakalatnama, please.
File it in the department. Today itself file it. Yes. Yes, Mr. Das, what is the matter?
Lawsuit, injunction matter lawsuit.
Injunction matter means your suit.
My suit for partition.
Section 5 is there first.
Yes. 255 days delay lawsuit.
Explanation?
Explanation the lawsuit suit was filed initially ad interim ex parte ad interim injunction was granted. Thereafter, suit was proceeded. Service was not completed, and every day I filed the application for.
You are the plaintiff. Your ad interim was refused.
No, initially ad interim was allowed. Ex parte. Thereafter, I taking step every day. Service summons was not service was not completed. Nobody was appeared. Nobody was filing any objection against the injunction application. On that day, also fixed for extension of interim order. I filed an application for extension of interim, but on that day, court below taking up the hearing of the injunction application, ex parte, and dismissed my injunction.
Have you annexed the previous order showing
Yes,
that?
yes, in my application. In my application, I annexed the previous order lordship, can 2.
So why the delay? That does not
Delay,
explain the delay.
I have no knowledge about the dismissal of the mandate.
It was a date fixed for
No,
extension.
date fixed for the extension of interim order. I taken step, but
You are present there.
in the court I am not present, lordship. I filed the application.
Your advocate was there.
Yes, but
you won't see the order.
the
It is not
advocate.
an explanation.
No, that advocate was not intimated to me.
Explanation has not been clearly stated in the application of the section 5.
Learned advocate.
Whatever explanation you are giving now, that is not an explanation at all.
No,
It was a date fixed.
No, learned advocate not intimated to me that the injunction was rejected.
Where have you stated that?
Page paragraph 5, 6, 7, and 8.
So, serve a copy of this application on that advocate.
Lordship, kindly see the para 5, 6, and 7. 5, 6, 7, and 8.
What is the stage of the injunction? Still pending.
Rejected injunction application, ex parte.
Oh, on that date only.
Yes.
Lordship,
1 minute. You have not a right of hearing before we hear them.
Paragraph 5, 6.
5 is not an explanation at all.
5, 6, lordship. There are
the explanation. Read out the explanation.
Lordship.
6 also no explanation.
The 5 lordship that neither the learned advocate nor the clerk of the plaintiff petitioner trial court informed the said fact regarding rejection of the injunction application under order to 39 rule 1 and 2 read with 151 CPC on 6/8/2024 by the learned.
That is actually the only ground that you are not intimated.
This
is not a good ground.
Lordship,
you are represented by an advocate.
Lordship, kindly see the impugned order, lordship. Date was fixed for extension of interim order.
Whatever, that is the merit of the appeal. But we cannot look into the appeal due to the 220 to 200 something days delay.
If
why did you wait?
But I do not know the injunction was already rejected. When I came to know,
blame has been given on the learned advocate. What were you doing?
When I came to know the fact, I take steps to taking the.
Came to know. What did you do for this 200 to something days? You did not contact your
every day.
advocate.
Every day, the date was fixed. Service was not completed. Nobody was appeared. And the extension.
After the dismissal.
Yes.
Did you not take information from your advocate?
Yes.
Where have you stated that?
Paragraph 5. Neither the learned advocate nor the clerk of the plaintiff petitioner trial.
5 is that he has not informed. Let us see 6.
6 of lordship, second week of May 2025, I came to know when the respondent trying to change the nature and character of the suit property. Thereafter, I taking step.
Where is the previous order? That
Lordship, previous order annexed in can 2 lordship. Page lordship 35.
No, next date was fixed for 39/7 application.
Yes. Lordship, kindly come to the impugned order. Plenty which present.
So you are represented then.
Filing along with the petition praying for extension of order of ad interim order of injunction.
See, you are present then. You are represented by an advocate.
Yes.
On merits issue, it was dismissed.
Yes.
Then.
But regarding dismissal of the injunction application, I have no knowledge. So that I cannot prepare an appeal within
Your
time.
knowledge is immaterial. You are represented by an advocate. He appeared and moved the matter. He was heard.
Yes. So that I cannot challenge the within time regarding limitation.
It is presented. Even on merits, you don't have anything.
Lordship, can
Represent it fully.
yes, trial court hold that I am the, I prove the my prima facie ownership.
Yes, what about section 5? What is your argument on section 5?
Actually, the actual reason of the delay of 25.
So it has been
25
expected
days
para
has
5 and 6. 5 and 6, they say he was not informed. Generally, clients don't go every day to their advocates. He took information, but first came to know when not in May 2025, you started changing the nature and character, changing the nature and character, they came to know and come. This is a plausible explanation. What is the difficulty in section 5?
But your lordship,
We'll allow the section 5 and take up the order 41. We're allowing this section 5. This is a plausible explanation. The explanation for the delay furnished in respect of filing the appeal in Can 1 of 2025 is that on the date on which the impugned order was passed, that is August 6, 2024, the matter was fixed for hearing of an application under Order 39, Rule 7 of the Code of Civil Procedure, and as such, the appellant stroke petitioner was not aware that the injunction application itself would be taken up. Even otherwise, the injunction application was dismissed on that day by the impugned order, which was not intimated to the appellant by his learned advocate or his clerk in the trial court. Only in the first week of May 2025, when the defendants allegedly tried to change the nature and character of the suit property, did the appellant approach his learned advocate in the trial court again, and upon proper search came to know that the impugned order has been passed dismissing the injunction application. Learned counsel appearing for the respondents opposes the prayer for condonation and submits that proper explanation has not been given in the application. However, from paragraph 6 and 5 and 6 of the application, we find a plausible explanation having been furnished, particularly in view of the fact that the appellant being appellant coming from a rural area and being a cultivator, might not have been expected to know the nuances of law and was dependent on his learned advocate. Accordingly, Can 1 of 2025 is allowed, thereby condoning the delay in preferring FMAT 289 of 2025. The said appeal is now taken up for hearing under Order 41, Rule 11 of the Code. Yes, why should you admit the appeal?
Lordship, fifth paragraph, Lordship, impugned order. On perusal of the document as furnished by the plaintiff, including a certified copy of the RSROR standing in the name of his predecessor, Nagendra Pradhan, along with the deed of settlement executed in his favor, and that together with LROR standing in his name, from which it prima facie appears that plaintiff has acquired the Co-1 scheduled property comprising within the co-scheduled property, and has also recorded his name in the present record of right. However, it appears on going through the record that no cogent original document has been filed before this court, including plot information in respect of the suit plot comprising plot number co-scheduled property, to substantiate the fact that the defendants are co-sharer with the plaintiff in respect of co-scheduled property, plaintiff or are having joint possession of the same within him.
So regarding Co-1 only, court says
Are
that
you praying for Co-1 in my property out of co-scheduled property? Initial injunction order, Lordship, ad interim injunction order, Lordship.
that was regarding Co-1 only.
No, both.
But
Co-1. My property is Co-1.
Co is the entire property,
Entire.
Co-1 is a part of it.
Lordship.
Your suit property is you are seeking injunction regarding entire Co.
Partition suit, Lordship.
Oh, it's a partition suit?
Yes, Lordship. Partition suit.
Yes, what do you say? Partition suit, there should be injunction.
Lordship, we
Suppose he proves his title regarding prima facie title regarding Co-1 only, that is a portion of the property. But if it's a joint property, unless partition is proved, they are co-owners of the entire property. So the entire property, there should be injunction.
the over the short scheduled property, we all have the right title and interest.
Yes.
We all have the, and
You all have right.
and we all
That is admitted by him.
appellants, we are in full blood relationship and we are living in a common hospice area. So
So you say that, so then there should be injunction. Why should you be permitted to transfer the property or alter the position. You are also in possession. Whatever will direct both of you to maintain status quo in regard of possession, and regarding nature character of the property, you will not be able to transfer the property during pendency of the suit.
I'm not transferring, but I have
That
to
is the
sign
injunction he has sought. So what is your problem to the injunction? You are co-owners. He admits you to be co-owners. That's a partition suit. So what is the difficulty if there is this injunction was granted?
We all have the right here, but how could he?
Because you are trying to transfer. That is his allegation. If you are not trying to transfer, then you won't be affected by this injunction order also.
No, I'm not trying transferring the property. As we all are full blood in relation, and we have the all title of interest of the
Full-blooded relations have the most chance of spilling blood of each other. That's a general impression. So we'll grant injunction, but restrain both sides from changing their nature and character, transfer, as well as disturbing the position of each other. We'll restrain them also. We'll grant and dispose of the appeal itself. Or keep it pending. We'll direct the suit to be decided. Is it a conscious choice, or we are not compelling you to do that? We'll make it an order of the court. Yes, you can say whatever you.
I'm praying humbly that the trial court order may kindly be affirmed.
All right. In view of questions of law and fact being involved, we admit the appeal to be heard on the grounds taken in the memorandum. Next para. Since the conspectus of the appeal is extremely brief, we take up the appeal along with the application for final hearing upon intimating learned counsel for the parties in order to save the parties the agony of a long-drawn unnecessary litigation. Next para. The present appeal arises out of an order whereby the plaintiff stroke appellant's application for temporary injunction was dismissed. The suit is one for partition. The learned trial judge, in the impugned order, arrived at the finding that the plaintiff has prima facie been able to prove that the plaintiff has acquired the co-1 scheduled property, which is a part of the co-scheduled property within bracket suit property, bracket close, and the said portion has been recorded in the name of the plaintiff. However, despite having so held, it was observed that other documents like plot information, etc., in respect of the entire co-scheduled property was not produced. Next para. Upon hearing learned counsel for the parties, we find that the plaintiff, even as per the learned trial court, has made out a prima facie case, at least to the extent that the plaintiff is the owner of a portion of the property, in the absence of any prima facie proof of the partition having been clearly demarcated and partitioned by metes and bounds by any of the modes known to law, all the parties, including the plaintiff and the defendants, are co-owners of the property, and as such ought not to be permitted to alter the nature and character or the ownership of the property during pendency of the suit, since any such alteration might ultimately prejudice the rights of both the parties at the final hearing of the suit. Accordingly, we are of the opinion that the learned trial judge acted erred in law in refusing injunction. Hence, FMAT 289 of 2025 is allowed on contest, thereby setting aside the impugned order number 19 dated August 6, 2024, passed by the learned civil judge, senior division, first court at Kontai, district Purbo Medinipur, in title suit number 781 of 2021, and disposing of the temporary injunction and allowing the temporary injunction application filed by the appellant in the court below in the trial court by granting by restraining both parties by an order of status quo from changing the nature and character of the suit property, and or from transferring, alienating, and or encumbering the suit property in favor of third parties in any manner, and or from disturbing each other's possession with regard to the suit property, all till disposal of the suit itself. Next para. It is expected that the suit, comma, being of the year 2021, comma, shall be disposed of as expeditiously as the business of the learned trial judge permits, comma, preferably within 8 months from the date of communication of this order to the learned trial judge. Can 2 of 2025 is consequentially disposed of as well. Affidavit of service file to be kept on record. No order is to cost. Thank you. একটা প্রশ্ন তো বলছে parents from-
That
Yes.
the relook, my lord, at the judgments.
Well, relook at the judgment. This is not a case on judgment. It's a case on facts. Purely on facts. There should be an agreement in existence. Let him show where is that agreement which he is seeking specific performance of. That is the.
Lord,
Mr. Chaudhary, just remind us in a nutshell. Just
Lord, the defendant number one, which is Lord ICICI Bank, wanted to sell Milord a property, and Milord, we entered into an agreement to purchase the property. Milord, there was a fixed time. The time stood extended from time to time. Ultimately, Milord, without selling it to us, they sold it to the defendant number two. I'm sorry, not the defendant number two. They sold it to somebody else. Post filing of the suit. Post Milord moving of the injunction application. In the written objection, there is no reflection of the sale. In the written statement, there is one sentence that the property has been sold. So, Milord, this is what has happened. When we moved the initial injunction application, that is before the sale, ICICI Bank was on caveat. So, Milord, written objection had to be filed, which is the usual, Milord, process if you're on caveat. That hearing is continuing even today. That's not been finished. Now, Milord,
no addendum granted.
no, no
Because they
addendum
were on
granted
caveat,
because
they
they
were
were
doing
on
some-
caveats.
Okay.
And the hearing did not, Milord, stand completed. In the meantime, they, Milord, sold. Now we filed two applications, one under Order 22 Rule 10 and the other under Section 94. For injunction, 94 read with 151, Order 22 Rule 10. Learned Judge, Milord, has come to a finding, which is, Milord, what I had placed on the last occasion, that in all such cases, it may not be subsequent purchaser, may not be required to be included or impleaded.
Suit is for specific performance.
Yes, this is suit for specific performance.
So why on the ground of privity it was held that
No, my lord, it was when we moved these applications, the finding, my lord, I'll just read out the sentences.
we'll just look into the impugned order.
Kindly see the impugned order. What is more interesting, my lord, is the contention of the purchaser, because they have been served with a copy of the appeal pursuant to my lord's
He's
order.
appealing for the purchase.
Mr.
You are for the purchase. You are the culprit.
Yes. That I'll just read out the last paragraph
Yes.
from the middle. It is prima facie admitted possession of the fact that the plaintiff has filed instant suit seeking legal enforcement of one
Sorry, we
agreement
could
for
not get
sale.
it. Middle of the last paragraph.
Yes, my lord, on the first page.
Oh, it is prime. Yes.
29th August
Yes, yes,
25.
Yes. Prime facie admitted
Yes,
position.
and there cannot be any such conclusion to be made by this court that the plaintiff has already acquired substantive right. There is no legal bar put on litigating party to transfer property. Then, my lord, last two lines. It is also well settled that there is no such necessity in all cases to implead any subsequent purchaser of the suit property, as the same may lead to create unnecessary legal intricacies, and it is also well settled that the result of the suit is always binding upon such purchaser as per Section 52 of the Transfer of Property Act. So, now this is the order. We came up in appeal. Appeal plot purchaser is the
No, what happened? The
nothing
applications have not
granted.
been dismissed.
Not dismissed.
So order 20 rule 10 is
No,
still
no, it's
pending.
pending. Now, my lord, what happens is
So
purchase
how
is
is it
not-
appealable? How this order?
that injunction refusal. Order 22 Rule 10 is also, my lord, appealable order. Should have been granted on the
It is disposed of only then.
but injunction, my lord, not granted.
Order 20 rule 10, if the application is either rejected or allowed, then it's appealable.
Yes, but injunction at least, my lord, can be considered. Now, purchaser,
Because Mr. Chaudhary, you have not yet got an injunction against the main,
Correct.
the vendor, the main defendant. So at this juncture, it would be premature to grant an injunction against the person who purchased through them. We can direct the injunction application along with this application to be heard out within a limited period. And if they have not filed objection, they'll file an objection. We'll fix a timeline for that.
Yes, but
And no
may-
reply is
may
required
I
in the
just-
trial courts.
my lord, just two things, my lord, may I indicate? On the
Yes.
first day, my lord, the argument was that the suit is, my lord, defective because there is no declaration. And for that purpose, my lord,
We shall also observe, Mr. Chaudhary, that these findings are only tentative in the nature and these would not affect the court while deciding the 2210 application. Because these findings we find are, I mean, just if there can be any obiter of the civil judge unit.
yes. Now, my lord,
These
no,
would not
I
be
am
fine.
more, my lord, worried
These are
about.
probably not correct to.
Yes. But I am also worried about something else.
No, these findings won't affect, but
No,
no injunction
but-
at this stage.
No, but the other thing which two arguments made. Number one, this is a property which their argument was I'm residing on the third and fourth floor,
We'll not go into that at this stage. We'll
which
not
is
go into that.
completely incorrect.
We'll not go into
Not
that.
perhaps wrong instructions
We will
given.
only on two grounds we will not be interfering. One is that this is at interim stage and no injunction has yet been granted against the original defendant. That's why, since they are claiming through the original defendant, it would be premature to grant an injunction against them. But at the same time, we will hold that these observations are only tentative. This would not affect the trial court at the time, at any stage. Deciding the injunction application,
Yes,
the
not,
2210, EO 94, and we'll direct both the injunction applications
be
because in
heard and
effect it's
decided.
39(1).
No, Order 22, Rule 10, Miller is. I would submit, Miller.
We can direct that to be heard first and then immediately after that the injunction.
That's akin to, Miller, matter of course. Admitted transfer by, Miller, the.
But this is not a deemed refusal of the Order 22 Rule 10. That would be
No,
going
but
too
that
far.
observation is dangerous, Miller.
That observation will say that there is. I mean,
It is
a
not necessary in all cases to impede subsequent purchaser. No,
This would not affect the adjudication of the. We
No,
find
but
that
unless I may not get the defendant, may not the purchaser as a defendant, I will.
So it's a catch-22 situation because if unless injunction is heard and injunction is granted against them, they may transfer before the 10/22/10 is heard out. Further transfer.
Yes.
And
this is the
unless
difficulty.
again, unless 2210 is allowed, they are not a party to the suit whether injunction can be granted against them. So we'll direct both 2210 and on both the injunction applications to be decided. They'll file
Together.
written objection we'll give them maximum of fortnight. If they have not
But
already.
they are demolishing. And though my lord, instructions, what I'm more worried is instructions given to learned advocates was wrong. I find after, my lord, we were indicated that it's not to be sold, used as personal residence, residing on third, fourth floor. I find, my lord, that this is a real estate project. And there is large scale evidence for that. Second, my lord, is the argument, which I'm sure they'll make again before the learned court below, which was made on the last occasion. In fact, that issue, my lord, can be considered by your lordship.
What?
As a dry question of law if required. According to them, based on a recent judgment of the Supreme Court, they say, my lord, that unless you ask for declaration, there is no scope of, my lord, specific performance. And your lordship wanted to hear the matter on that question. My lord, if your lordship recalls,
Declaration regarding subsequent deed.
if you file
Declaration
a
of what?
suit for specific performance, and if the agreement, my lord, has been terminated,
Oh, that.
then that is, I did some research on that, and what we find, my
Yes,
lord,
yes.
my lord, may I
He provided your judgment and you provided his
Yes.
judgment.
No, I'm grateful to Mr. Banerjee for providing the judgment. But, my lord,
Not
1968.
you, your client, all along.
Yes. But if your lordship sees, my lord, may I just very quickly show your lordship? My lord, this
Mr.
is,
Chaudhary, if we go into that question either way, it will definitely prejudice the trial court. Even if because the injunction application is still pending, both the injunction applications. Either way, it will prejudice. You can make your arguments before the trial court on.
these are only, this would be, my lord, something which will ensure.
We cannot preempt that argument in the trial court. Let
That
it
if
be
that
maybe
issue,
trial
my
court,
lord,
let
since
it be-
that point was taken before your lordship.
No,
if
but
your
that
lordship
does
is-
not entitle us to use up the jurisdiction of the trial court because if we direct both to be heard together, No adjudication has yet been made on their rights also to get.
No,
or
no,
your
I am
rights to
not
get
saying that. I am not saying
will not
that.
prematurely do that at this stage because nothing has been done. Deemed refusal, you may say definitely, but till date you have not got an injunction against the main defendant.
I accept that.
And the suit is when was it filed? I mean,
2024.
2024.
Injunction is pending even now. It's
Injunction
an infructuous.
That will direct both the injunction applications to be taken up together. Both will be considered because they are claiming through them only. Mr. Banerjee's client is claiming through, sorry, the other way around. Mr. Mukherjee is claiming through Mr. Banerjee.
But Milad, I want my injunction to be heard. I
We will
can,
direct that. Within 2 weeks, written objection. Within a week after that, the injunction.
but with these 4 judgments, I can't
It will not
expect.
be to all the 4 judgments. No, we
but
cannot. We cannot prematurely comment on.
Milad, may I, Milad, do this?
Don't
May I-
underestimate the district courts, Mr. Chaudhary.
No, I am not.
Often,
Milad, for once.
they are much better than us.
No, I don't underestimate at all. But I don't want a situation where, Milord, I am lost in this legal, Milord, quagmire.
You are already lost in the legal quagmire. You have invited that legal quagmire by filing a suit.
Milord,
You
kindly
cannot
give-
avoid legal
Milord,
quagmire.
in that
whenever
case,
it-
Milord, kindly give me 3 days time to file an application for amendment and direct that also to be decided.
Amendment of what?
Milord, of the plaint, I'll Milord include a prayer for declaration. It's within June. It's within
Will
time.
not permit you to file an amendment application. You can file an amendment
But if
application.
your lordship only observes
No.
that if I file, that may be considered along
Why
with
should
this.
we observe that prematurely? There is no application on board. Why should we say?
Because otherwise, if your lordship sends me
It's
back,
like saying if the trial court feels the trial court may degree the suit.
no. All the time
If
saying
you
is,
file an amendment application, that should be considered. That will be considered.
along with these within the time frame. That's all that I'm asking. My statement that I will file, and
Then
if
the timeline has to be more.
3
If you
weeks,
file within 3 days, that
yes, I'll
amendment
file within
application,
3 days.
they are also required to file an
Yes,
objection
please
to
give
that.
them 2 weeks, my lord. I have no objection. In 2 weeks, heavens will not fall.
This building may fall, heaven will not fall.
Building
This
will
building will fall.
No, but we'll also similar after 2 weeks we'll come and we'll fight out the Lord,
So if that be so, then we'll give after these 2 weeks, another at least a fortnight's time to the trial court to take up.
yes, please, my lord. So, my lord, even then I'll get a disposal by the end of December. So, my lord, that inures to my benefit.
No, would you? No, you won't, because 1/8.
No, my lord, these are dates I'm very
Yes,
familiar with.
barely.
The timeline between the present and the next holidays is something which I am very well versed with.
So we'll do that, Mr. Mukherjee and Mr. Banerjee. We are so very happy, Junior Mr.
Milord,
Mukherjee.
But I found an answer to, my lord, the argument.
No, we'd love to do that, but Mr. Chaudhary, not at this stage.
No, I understand.
Point out that the order 2010 was sought to be moved by him ex parte without serving notice on the defendant. That's why the court has said that without giving reasonable opportunity to the defendant, why will I hear out the question? The last paragraph was
Since we're not decided.
relevant to mention.
But these observations, if you seriously go into these are not correct observations.
They may not. But,
It's arguable, maybe, but these are not correct.
but Lord, he didn't serve even the copy. He filed a put-up application with the 22 Rule 10.
So we are taking up the appeal, deciding the appeal itself with the consent of the parties. That much. The appeal is admitted, involving questions of fact as well as law, for being heard on the memorandum of appeal. Next para, on consent of all parties, the appeal itself is taken up for disposal along with the connected application. Next para, the present appeal arises out of an order whereby the learned trial judge postponed the hearing of an application under Order 22, Rule 10 of the Code of Civil Procedure, as well as, in a deemed manner, refused to grant ad interim injunction on an application filed by the plaintiff stroke appellant for injunction against the proposed added parties. Although the latter application was captioned as one under sections 94 and 151 of the Code of Civil Procedure, in substance, the power of the court invoked by the said application was under Order 39, Rules 1 and 2, and hence, we entertain the appeal. Next para, the grievance of the appellant comma, as ventilated by learned senior counsel appearing for the appellant is that the appellant filed the suit for specific performance of a contract against the defendant stroke respondent number one is the defendant original.
Yes.
Respondent number one.
Respondent only, my lord.
Oh, acha. Right. The respondent. Push up next para. During pendency of the suit, comma, it is alleged that the subject property of the agreement was transferred by the defendant stroke respondent to a third party who are also represented before us today. Push up next para. Learned senior counsel for the appellant argues that the application under Order 22 Rule 10 or 2 have been allowed as a matter of course in view of there being a transferred lease pendants. However, comma, the learned trial judge, comma, in the impugned order, comma, arrived at certain observations which might adversely prejudice the interests of the plaintiff, inasmuch as it was internally observed that unless any decision is arrived at as to the legal enforcement of an agreement for sale which has been sought to be specifically enforced, comma, there cannot be any such conclusion to be made that the plaintiff has already acquired any substantive right. So it was also observed that under such circumstances, comma, there is no necessity in all cases to implead any subsequent purchaser. Next para, it is argued that the said observations are not legally tenable. The contentions of the appellant are disputed by learned senior counsel appearing for the defendant respondent and the proposed added parties in the suit respectively. However, comma, upon hearing learned counsel for the parties, we are of the opinion that it would be premature at this stage for this court to comment either way on the outcome of the pending applications. Next para. Since till date, no ad interim injunction has been granted against the original defendant itself, comma, albeit primarily because there was a caveat and hearing is going on, comma, we are of the opinion that it would also be premature to grant an injunction against the proposed substituent defendants, comma, since the latter claims its rights through the original defendant against whom at present no injunction is subsisting. Next para. Be that as it may, comma, since extreme urgency has been pleaded by the plaintiff stroke appellant, comma, it would inure to the benefit of all in the event the the pending original injunction application as well as the subsequent application filed in respect of the proposed added defendants are heard along with the application under Order 22 Rule 10 of the Code of Civil Procedure expeditiously and together. On the prayer of learned counsel, senior counsel appearing for the appellant, comma, we grant liberty to the plaintiff stroke appellant to file an application for amendment to the plaint within 3 days from date. If such an application is filed, comma, the learned trial judge shall permit a fortnight's time to the respondents and the proposed added defendant, respondent and the proposed added defendant to file written objections thereto. Written objections to both the injunction applications, comma, if not already filed, shall also be filed within the said period of a fortnight commencing 3 days hereafter. Next para. The learned trial judge shall dispose of all the 3 applications, comma, being the original application under Order 39 Rule 1 and 2, comma, the second injunction application and the application for addition of party stroke substitution under Order 22 Rule 10, comma, alternatively Order 1 Rule 10 of the Code of Civil Procedure as expeditiously thereafter as possible, comma, positively before the closing of the trial court for the upcoming winter vacation. Next para, we make it abundantly clear that the merits of the matter or the application for amendment which is to be filed, comma, have not been gone into by this court in any manner whatsoever. So we further clarify that the observations made in the impugned order were of a tentative nature and the learned trial judge shall not be bound by the said observations at any stage of the proceeding, comma, either at the stage of disposal of the above applications or the suit itself, full stop, since any comment, comma, either way, comma, on the merits of the matter or on the merits of the said observations by us might prejudice or influence the learned trial judge at later stages of the suit, comma, we deliberately desist from doing so by keeping it open to the learned trial judge to decide all applications, pending applications and the suit without being influenced in any manner by the said observations. Full stop. Next para. In the light of the above observations, comma, FMAT uh, uh, 420 of 2025 is disposed of without interfering with the impugned order, but in the light of the directions given above, uh, without interfering with the impugned order dated August 29, 2025, passed by the learned civil judge, Senior Division, Second Court at Alipur, District South 24 Parganas, in title suit number 273 of 2024, in the light of the directions given above. What other can is pending? Only can 1 is pending.
No, can 2 we have filed in order to bring on record that this is a real estate project. And the instructions given, my lord, to learned advocate.
Can
were
one
not
of
correct.
can 1 of 2025 and can 2 of 2025 are disposed of consequentially?
That only one prayer, my lord. No, of course, we'll serve you today.
We'll do that. Yes.
No, just one prayer, my lord, that sentence that if amendment is filed, it will be disposed of along with these matters. Possibly that has
All yes, we have directed all.
Your lordship has directed substitution to injunction
আচ্ছা যেখানে
applications.
বলেছি না সবকটা একসঙ্গে শুনানি হবে the first original injunction application, the second subsequent injunction application, and the application under order 20 rule 10 read with rule লিখছো কেন আবার বলেছি এখানে দেখ কোথাও লিখেছি আমি যেখানে আমরা ডিসপোজাল করেছি অ্যাপিলটা ডিসপোজ করেছি dispose of the application, original injunction application.
Fully built up.
ওখানে ওই সেন্টেন্সে যেখানে শেষ হচ্ছে along with the amendment application, comma, if any, filed by the plaintiff stroke appellant. আর লাস্ট একটা লাইন করে দাও copies of all the applications, comma, if not served, shall be circulated among the unserved parties by tomorrow.
But, actually, Mr. Mitra shouldn't have appeared, my lord, to oppose this, because all his life he's been saying that do not pray for declaration. Whenever I would write it, he would scratch it out and say this prayer is inbuilt. Don't uselessly ask for declarations. Estoppel by settling. But 1960
change with time.
Yes, that's why, my lord, I don't want
law
to.
is a growing thing. Law is something very growing. Law develops.
But 1968 Supreme.
It's a nice way of putting it.
No. Well, one has to.
No, this is completely contrary to whatever you have always said.
This matter is over. We'll sit for the next matter after 10.
Not you can have a laugh over this matter.
Number 16 with 17.
This way.
Yes.
My lords are hearing two appeals from two separate orders. The first, item 16.
Yes. দুটো appeal দিয়ে Yeah, just please remind us, Mr.
Yes.
Chatterjee, in a nutshell, why two appeals, just the background.
The first
You told
one,
us yesterday.
in
this-
item 16, the ad interim order granted by the Honorable High Court was vacated on an application under Order 39, Rule 4. That is item 16.
17?
Item 17, I say collusion, the person was set up, Mr. Chatterjee's client. He obtained an ad interim status quo ex parte. After the appeal was adjourned before the Honorable Vacation Bench, because in spite of caveat, the principal defendant chose not to accept service. That is recorded in the order dated 14th October. They, taking advantage of that, files a suit, manufactures documents, I say, and then gets. But the more important is the first appeal, the item 16. But page 62 is the order of the Honorable Division Bench, which was vacated. Item 16.
Page?
Page 62.
60.
But in
Yes.
page 63,
Yes.
my lord, the first portion deals with the section 5 and all that. Page 63, my lord, in the third paragraph at the top, about the sixth line, one name appears, my lord, Deepak Shankar.
Yes, Deepak.
He is actually the person who has been set up, the person who was resisting my clients in collection of parking fees.
So your suit was for what?
My suit was for declaration and injunction. Declaration that there are two portions, the two sides of this particular row, Jogendra Kobiraj row. I say that the corporation has authorized the society to collect parking fees from the eastern side, and that is in respect of which the injunction was sought, and my lords had, on my appeal, granted such an injunction. There was an earlier suit in respect of the western side, which transpired, well, it's recorded here, that is not the authorized part. The corporation did not authorize.
But got an ad interim injunction regarding this portion.
Yes. I'll place, well, 2 or 3 paragraphs.
So this order was against what? This appeal was against what? This
refusal to grant.
ad interim.
Well, kindly sees paragraphs 30, 31, and 32. There was a rider, actually, well, at page 70. The internal page 9.
Yes. Allowed sitting as it. Remuneration, yes.
And paragraph 31 is the important paragraph. It is made clear that the above injunction is granted subject to the condition that the appellant shall go on paying the remuneration as fixed by agreement between respondent number 1 is the society and the appellant to the respondent number 1 for collection of parking fees from the eastern side of this road. Our case was that
they were originally, the Borabazar Fee Parking Cooperative Society was originally granted that permission by the corporation. They sub-licensed it to you. Very. This was the rider.
Yes. And paragraph 32 spelled it out. In default of such payment, it will be open to the respondent number 1 to apply for vacating it. Our case was that there was no agreement in respect of the eastern side. What was treated, my lords may come to the impugned order, the memo of appeal. The learned court held that there was an implied contract proceeding on basis of the amount, memo of appeal. That is annexed there.
Yes. The impugned order.
Yes. Page 7 and 8 of the judgment. The findings. Paragraph 9 onwards.
Right.
Now, the position of the petition of the plaintiff praying for temporary injunction is taken up. On perusal, it reveals from materials on record that the ad interim injunction was granted by the Honorable High Court, Calcutta, on condition to pay the remuneration as fixed by agreement between plaintiff and defendant number one. The defendant number one has agitated the point that the plaintiff has failed to comply with the condition since she is not depositing the daily parking fees to the credit of the defendant number one. The papers documents as filed by the plaintiff indicate that they are paying rupees 300 as daily parking fees in the credit of the defendant number one. The plaintiff has denied the existence of any agreement with the defendant number one with respect to the amount of daily parking fees. But the assertion in the plate shows otherwise, as initially she was paying an amount of rupees 1,200 per day as daily parking fees till December 2021, as reflected in the job cards annexed to the plate. Learned advocate for the defendant number one has argued that there was an implied contract with the plaintiff after demise of her husband, the erstwhile permanent employee collector Subhash Mali, since deceased, to pay rupees 1,200 as daily parking fees to the defendant number one, and the defendant number one was paying rupees 5,000 as salary to the said plaintiff, and both parties fulfilled their obligations regarding the daily parking fees as well as the payments of salary during the year 2021, and the job card issued to the said plaintiff also corroborates the same, and it is also admitted in the plate. Learned advocate for the plaintiff has submitted that there is no agreement with respect to the amount of rupees 1,200 as daily parking fees to the defendant number one. In view of the submissions made by both sides, it would be appropriate to ascertain the conditions. My Lord will skip that. Annexure 18 was taken up, my Lord. Middle of the next page, towards the top of the of the plate indicates a job card in the name of Poonam Mali, plaintiff, wherein collection deposits was made at rupees 1,200 per day for January 21, August, October, and December. The others, my Lord, next para 13. It appears that after the demise of Subhash Mali, my husband, the permanent collector, the plaintiff being his wife widow, has been assigned temporarily as collector by defendant number one for a certain period, which is extended time to time. After appointment as temporary collector for the scheduled car parking area, the plaintiff started to make daily deposit of rupees 1,200 as car parking fees till December 2021, which is reflected from the annexure 18 to the plate. The conduct of the plaintiff indicates that there was an implied agreement. As such, an implied agreement is legally binding contract formed by the actions and conduct of the parties rather than by explicit words or writing. Admittedly, Milad, it's a repetition really, Milad. Then towards the bottom of the page, their actions demonstrate a shared understanding and commitment to an exchange of services or things and salary. Even though they are not written, implied contracts are just as legally enforceable as express contracts. Consistent past actions between the temporary collector plaintiff and agency defendant number one, repeatedly sending daily parking fees to rupees 1,200 to defendant number one, and paying salary at rupees 5,000 per month by the defendant number one, has created an implied agreement to continue the pattern. But this is all. That is the gist of the judgment.
So this was, the court was taking up what? Order 13 Rule 4?
Yes.
So
on the basis that there was an implied agreement between the parties of payment of 1,200 by me to the defendant's
Since
society.
they failed to comply the conditions, so it was lifted.
Yes. But my case is that there was no agreement, either express or implied, regarding the eastern side of this road.
Mr. Chatterjee, this is a one of the plausible views taken by the court. You may have a point when you say there is no written agreement, but the court relies on certain past conduct of yours and consistent payment of at least 3-4 months to hold that there's an implied contract. At this stage, this is one of the plausible views. So why should we interfere?
Because there's a
Now, we said as per agreement between the parties, we kept it vague.
because this annexure P18 that is
Yes.
at page 183.
Yes.
This is what is called the job card. This
1200
clearly
per-
mentions that the
Yes, 1200 per day.
12 is in respect of the western side
Oh.
at the bottom. The subsequent months, all the details were not there.
So all the payments you say were for the western side.
Western side. And the eastern side, I'll place documents, everything is there. But I'll just
So the
place.
entire premise of these findings was this. This is Exhibit 18.
Yes. But I have to clarify that this was the first month, January 2021. All the details are here. I have the original with me.
Is there any single document to show that for the eastern side you ever paid anything?
No. And why that is an impossibility, I tell my lords. My lord, because the corporation, my lords will find that from page I'm drawing my lord's attention to the stay petition again, to page 30. I may be wrong, my lord. Page 25. Page 25. Page 25. There's a legible typed copy on the next page.
Yes.
Serial number 16 is Jogendra Koviraj Row.
Mm-hmm.
And the number of cars that can be legally parked is 5. If my lords now turn to page 94, which is really a part of the written statement of the corporation filed in the suit, but the amount that I can legally charge from a car is rupees 10.
50 total. Max. No, it may be more than the hour.
10 hours, my lord. It is shown as
But
10.
10 hours, it's
For one car. For
one car.
It is 50. 5 into 10.
Oh.
I'm sorry. For one car, it is 100. Rupees 10. Rupees 10 for 10 hours is 100. And for 5 cars, it is 500. For one car at the rate of rupees 10 per car, I can collect 100.
But we get the hours.
Hours
Day
are
car
there.
parking lots.
Hours are there, my lord.
It's day car parking. So
The office, Bara Bazaar, it's shown somewhere in the job card also. It's a totally desolate place in the night. And this is only a part of the story. But this bulk of the petition is due to the complaints filed by my lords will recollect that she is a widow. At the time of her husband's death, there were 2 minor daughters. Now there's 1. And the hurdles that she faced and the complaints that she has made to the authorities, but I draw my lords, that is the comprising the bulk of this, page 130 of this.
So what have they done after the complaints? You made the complaint.
Even POXO, yes. Even POXO case has been started against somebody who claims to be a lawyer and somebody whose name appears in the Mr. Chatterjee's team before my lords.
The POXO case has been registered by you.
In respect of my minor daughter. And
how do you know that that is not vindictive?
Because the trial is proceeding, and my lord sees the nature of the
taking up POXO cases in the bail bench. We had an idea that I had an idea.
Yes, I can very
that
well
one
imagine
cannot
that.
use one's children.
Something like a dowry.
But
case.
now that idea is
dowry case. Also.
We have any preconceived notion.
Kindly sees, my lord,
anyone can be used by anybody.
Anyway, my lord, the basic fact is resistance by the society itself, is secretary. The person who is now the plaintiff in item number 17.
Now, the Mr. Chatterjee, it may very well be that you being a widow lady and having minor daughter, you are being harassed, And at the same time, it may be that you are using that as a card.
My lord, will for the moment.
So let us not go into that.
Yes, but my
That
lords
be
will.
decided by the
My
committee.
lord, yes, yeah, that will be decided in the.
But yes, this is a palpable document. I mean, a palpable proof that it was regarding western side only. What was our premise of holding? Their arguments that the whatever is chargeable under the agreement. What is the reason for that finding?
No, my lords were conscious of the fact that there was no written agreement.
So, was it discussed anywhere? I mean, or out of the blue, we said that because it was argued by the other side.
And it was not argued, but
it does not.
The defendant was represented. Kindly turns back to page 62.
Okay. You have filed a parallel suit also.
In my suit, this
Western.
ad interim in Eastern. Western was withdrawn after my lord's direction.
What direction did you?
My lords had directed me to withdraw the suit in respect of Western side as soon as possible.
Withdraw. How can? Let us see. On what premise? Why did you direct you?
Paragraph 27. That was when I was not aware that the Western side is not the correct side. At the bottom of 69.
You are putting
page 69.
Head. We observed that at this must have happened something. Learned counsel for the appellant you, on instruction from his client, submits categorically that his client, the appellant herein, undertakes to abandon, withdraw the prior suit in respect.
Thus, it is expected that.
Thus, it is expected that appropriate steps in that regard.
Because there are two parallel suits.
Pass in a direction on you. You chose to abandon on your client's instruction because of the previous observation as regards the pendency of a different suit by the appellant in the same breath regarding western side of the self-same road and eastern side on the self-same.
But my lords had held that the eastern side is the lawful side.
Very well. The agreement, where does it come from? Let us see that. Regarding western side, there was some agreement.
No, that
there was no agreement regarding either side.
No, that is where merely cars are parked by Mr. Chatterjee's clients. But let me place page 41. Page 41.
Chatterjee's clients are like Mr. Chatterjee.
Page 40. Yes, everything has the story has really developed after Mr. Chatterjee entered the.
You cannot equate yourself with Mr. Chatterjee.
Page. I was there all along. Page 41 of the plate.
41, yes. This depends on the type of the car also.
and the other thing, there are photographs that they are deliberately damaging the cars parked on my side.
We will not go into that. Why?
Page 41.
41, yes.
This page 41 is a portion of the plate actually.
Which portion are you wanting?
I'm relying on my kindly reads from.
The question of agreement come. That is what we are.
The agreement actually comes from the fact that my lord sees 1, 2, 3, 4, fifth line at page 41. Despite the said fact that parking collections remained low during the prolonged pandemic situation, the defendant number 1 almost doubled the daily collection to be realized from the plaintiff, and the plaintiff had to agree to pay 1200.
This is your plaint.
This is my plaint. This was shortly after my husband passed away, and this.
Then you have admitted in your plaint,
but forced to. I say that even if this was in respect of
this coupled with our direction that as per agreement you have to pay human being or things. Something must have fallen.
My case is that she was forced to agree. After her
forced to agree or not, Mr. Chatterjee, you have to prove in your suit.
Yes, had to agree. Had to agree.
It
was a compulsion is hinted.
Yes, we understand, but at the same time, there's an agreement. You had to agree or not had to agree.
There was no agreement. For a few months after
Once say you had to agree to payment of 1200, you were bound by this.
In respect of the western side. There I was.
This suit is regarding the eastern side.
This suit.
And this is the plaint of this suit.
This was the recital of what had happened in the past. That this followed 183.
The scheduled property is eastern side, and there you say that
this was
to agree.
The history is the earlier suit and all that is.
The history is also connected to the geography because eastern side,
Eastern side came
the suit
after
is
my
legal
lord.
eastern side. You say
Eastern
that I
side-
was supposed to agree.
Eastern side came when my lord will see at page 30.
Mr. Chatterjee, please read para 10 of your plaint as a whole. Page 40.
And then my lord's
Once again, you say, his appeal is allowed.
The plaintiff on several times requested the defendant number 1 to allow her to operate as collection fee of the fee parking zone at Jogendra
Eastern
Kovira
side.
eastern side upon payment of the daily fee of 640 per day in place.
And this
The-
is what was enhanced. You say you are forced to answer because you continue with that. You
Yes.
say eastern side upon payment
Eastern
of
side comes in only at page 30, October 2021.
whenever. So para 10, you say that you are a collection employee, eastern
Although
side,
Eastern, they are making me
upon,
collect from the
upon,
Western.
upon payment of daily fee of 640, the defendant number 1 orally entrusted to the plaintiff to operate as a collection, what you repeat, temporarily on and from such as at a daily fee of rupees 1200 payable by the plaintiff.
But
So
this was read with
consistent-
page 183. Page 183. It's
No,
clearly
page 183 is a document regarding the western side. This cannot be read with
this is in respect to the Western side. Eastern side was implemented only after my lord's order.
No, your statement, your plain statement says, allow her to cooperate as the collection employee of the fee parking zone at Jogendra Kobiraj Row, eastern side upon payment of daily fee of such and such. The defendant number 1 orally entrusted to the plaintiff to operate as the collection temporarily daily fee of 1200. You never mention even western side in paragraph 10.
My
It's
lord,
all
will,
about eastern
my
side.
lord will read on to the next paragraph 11.
Yes. Again, eastern side. Consistently eastern side.
This was
Mention
when,
about western.
this was Western side that is being collected.
You read out eastern cannot be read as western.
That
Day
when
can be made night. You say eastern, EASTERN spells out, I mean, pronounces as eastern. What did it
She
say?
was what?
It's your explanation from the bar, Mr. Chatterjee.
No,
Sorry.
this is
Your
not
plain
my.
reading is different.
My main pleading stems from annexure that page 183, which
Plain pleading has to stem from the plaint, Mr. Chatterjee. Para 10 and 11 is very clear. Eastern
Kindly
side, you
see,
mention
reads-
bracket.
then my lords have to read from para 9, where the story starts. But the
So he's
defendant
starting
number,
from different paragraphs the moment we ask.
the defendant number 1 illegally started to operate the fee parking zone at Jogendra Kobiraj Row Western side, which was illegal, and upon the basis of reason, the one High Court had passed an order, no Western side parking.
That's what I'm saying.
Suddenly, my lord, in the year 2021, during the pandemic, the defendant entrusted the plaintiff to operate the fee parking zone at so-and-so Western side as the collection employee at a daily fee of rupees 1200. I mean, what
Western
has to be
side was
called out-
illegal. Therefore, you asked for
Yes.
the eastern side.
What has to
You
be
said
called-
that was given to you upon the
that
same
was
page.
not given to me in spite of a letter to that effect.
Para 10, Mr. Chatterjee, let us not waste time on this. We are repeating ourselves. Para 10, 11 is very clear.
9 is Western side.
9 was western side.
Yes.
You say western side was illegal. Therefore, the plaintiff in your language, several times requested defendant number 1 to allow
But
her
that
to
was not
operate.
allowed. That was not allowed.
Then
That
how
is
did
why
you
I had
file
to
the
come to
suit?
court.
You filed the suit in respect of eastern side.
Yes, that claiming that I may be allowed to operate eastern side, no injunction granted, my lord.
The plaint should be rejected then.
Protected
if you
me.
say that it was never granted to you. Your plaint relief is declaring that the plaintiff is the bona fide
The plaint stems
Sorry,
from
Mr. Chatterjee. Your first relief is declaring that the plaintiff is a bona fide collecting agent under the defendant number 1.
Yes, because
continuing to run the fee parking zone at Jogendra Kobiraj Row eastern side. This will reject the plaintiff.
because
You
of
say it
page
was never granted to you.
because of page 30, my lords had laid much emphasis on page 30. Kindly seize while passing the ad interim protection.
Your plaintiff
Page
is very
30.
clear.
Kindly seize page 30.
Whatever is there.
Page 30. Kindly seize page 30. Kindly seize page 30. This
Yes,
was
sir.
the document which
You
persuaded.
cannot look at the proof without pleadings. You cannot go beyond your pleadings. Para
This-
10, 11, very clear. Western side was illegal, so you asked for eastern side permitted, 641st, then 1200. Then this 1200, you seek a declaration that you have a right to do that. And now you say it was never granted
I
to
seek
you.
a declaration that I am in kindly seize page 30 for once. Page 30.
No, we.
Our case was that in spite of this, I was not allowed to operate the eastern side. Page 30.
You have not paid 1200 per month. You
Page, kindly see page 30.
Yes, we have seen page 30. So what?
This is what prompted my lords to pass an interim order.
We don't know, but your plaint says otherwise. This does not say, this is eastern side.
Yes. Our case was that in spite of being authorized, my lords will kindly go through the earlier order.
Yes, yes.
I was not being allowed to, my lord.
Therefore, you are authorized by the letter. But you in para 10, you say that you ask for being allowed to operate eastern side, and then you say the defendant number 1 orally entrusted to the plaintiff to operate. How can you deny your own plain statement?
The
para 10, the second sentence, you asked for it, they gave you it. The defendant number 1 orally entrusted to the plaintiff to operate as the collection agent to collect temporarily such and such. Then assured the plaintiff to appoint. So you asked for eastern side, they gave you eastern side, 640 was the initial rate, then had to agree to pay 1200 per month, then all these things. Your plaint says otherwise. Sorry, the court proceeded on your plaint, the trial court.
The court
Let's go
did
beyond
not,
your plaint.
the court, the learned court did not distinguish between the
This supplies
eastern and the
basis.
western side.
Western side does not come in at all. Western side, you might have paid 1200 per month. That does not have anything to do.
I have never paid 1200 in respect of the eastern side. Never. And that is an impossibility. I explained that position to my lord. The only document, my lord, which has 1200 written on it is in respect
your
of western
plaint says,
side.
sorry, your plaint says otherwise. Your plaint says you started with 640. Have you paid 640 to them per month? Rupees 640?
640 initially after my father.
No, after our order, did you?
No.
You paid nothing.
I consisted. That is recorded correctly.
How much?
300.
What does 300 come from?
300 came from the collections, less the amounts that I had to deposit because of cases being slapped on me by the police. I deposited those amounts in the Lok Adalat. I said so in my application, and I have the.
Sharif, what is the other appeal about against?
The other appeal is they have got a status quo in respect of eastern side.
Status quo means you cannot collect.
No, Mr. Chatterjee, Aniruddha Chatterjee's client has got a status quo in respect of eastern side because the case now made out is that
they were not parties to the suit initially.
In the first suit, they were not parties.
This is a second suit from which the second appeal.
There, my lord, there they claim that they were authorized to collect from the eastern side. Although, my lord, never before my lords, nor ever in the pleadings in the learned court below was the case made out.
The two suits are before the same court, Mr. Chatterjee?
Yes.
We'll club the suits. We'll club the suits.
But I have to, my lord, sustain myself. Well, he is continuing to collect from the western side in collision with the
western
police.
Side, forget western side because that's out of the purview of this suit. Eastern side is the subject matter of the suit. Your player, your schedule, and your averment. Where you say 640, at least 640 you should have paid them. Then we could have any.
I will pay.
We don't have any handle
but
now
because
to come in your favor.
Because of the amounts of fine.
You see, initially they agreed to 640. Pay. You should have paid that at least. We would have some handle to pass an order in your favor.
Kindly seize the resistance. The cars are damaged. I have to compensate the owners who parked their cars.
That's a different thing.
But the basic thing was that there's no agreement.
Anyway, you have challenged an order whereby the injunction was vacated because you did not comply with our order, directing you to pay monthly.
There was no direction to pay 1,200.
No, we don't agree with you.
But there was no direction.
Let us dismiss this appeal, then we'll go on to the next appeal. Or
kindly seize, my lord.
No, we won't admit it in our particular. We have nothing here. We'll refer to the plaint. We'll give our reasons.
Actually, but
the reasons given by the trial court, you may have a point, Mr. Chatterjee, were not so satisfactory because it relied on Exhibit 18, which is in respect of western side. You have a point there, definitely. We'll say that. But the conclusion we agree with. But you paid 300. What does 300 come from?
300 max is 500, but less the fees that I pay to the police, the fines. Well, let's seize the second appeal.
Who is appearing for housing society? You are appearing for. Not housing, Barabazar, that society which collects parking society.
If my lord, and I am just badly comes and Page 113. They have the memo of it.
Page
113.
Application.
Application.
Honda.
300 per month.
Not 300.
See, I don't dispute 300.
If my lord comes to the date, they have the column date.
Yes.
20 February 2025. 225th February 2025. Amount 300. For 5 days, they have paid 300 in a prime location of Calcutta.
And we directed them to pay daily.
Daily.
This is all daily.
And daily is their plain terms.
Patients. 21 to 27. For 6 days, they have paid 300 in a prime location.
I have paid 300 all along. I have paid 300. The Learned Court has held that I have paid 300 all along. My lords will see the
Society, we are striving.
my lords will see the nature of resistance that I face. And I'll make an effort to increase this to 600. 1200 is not humanly possible. My lord, that what has been said, kindly sees the manufactured documents, my lord.
We don't find any illegality in this order, impugned order.
Apart from that
If
page
you
180.
had paid 640 already, we could have considered, Mr. Chairman.
Page 183 kindly sees. There's no way that I can pay 1,200 in respect of the eastern side.
No, we are dismissing the appeal. The first one, then second one will hear it, whether they can have a status. The present appeal arises out of a suit filed by the plaintiff stroke appellant for declaration that the plaintiff stroke appellant is a bona fide collecting agent under the defendant number 1 stroke respondent number 1 and continuing to run the fee parking zone at Jogendro Kobiraj Row within bracket eastern side and for ancillary reliefs. For next para, learned counsel appearing for the appellant argues that the learned trial judge, although granted that the learned trial judge initially refused ad interim injunction against which an appeal was preferred before this court. A division bench of this court, video order dated February 17, 2025, passed in the said appeal, bearing FMAT 175 of 2024, had allowed the appeal, thereby setting aside the order impugned therein and granting ad interim injunction, restraining the defendant stroke respondent number 1 and its men and agents from disturbing the collection of parking fees by the appellant on the eastern side of Jogendro Kobiraj Row, ROW, till disposal of the injunction application in the trial court. Simultaneously, however, it was made clear that the above injunction was granted subject to the condition that the appellant shall go on paying the remuneration as fixed by agreement between the respondent number 1 and the appellant, to the respondent number 1 for collection of parking fees from the eastern side of Jogendro Kobiraj Row. In default of such payment, it was recorded, it would be open to the respondent number 1 to apply for vacating the interim order before the trial court. Next para, subsequently, although the appellant claims to have gone on paying rupees 300 as parking fees, the learned trial judge, by the present impugned order, vacated the ad interim order of injunction on the application made in that regard by the defendant stroke respondent number 1 on the premise that the default clause of the order of this court in the previous appeal was operative, since the remuneration payable by virtue of the agreement between the parties was not paid by the appellant. So next parallel and counsel disputes such contention, such proposition and submits that although there was an agreement between the parties to pay at the rate of 1200 rupees 1200 per month per day as collection charges remuneration, the same was not applicable to the eastern side of Jogendro Kobiraj Row. Next para, it is alleged that due to the harassment being suffered by the appellant at the hands of the agents of the respondent number 1 society, by not only damaging the parked cars, but also attempting to harass the family of the appellant, the collection is suffering. That apart, it is submitted that there was no written agreement between the parties at any point of time of any such payment being made. Learned counsel places particular reliance on the admitted rate charts for various categories of day car parking lots, from where it appears that at the most, five cars, two, 10 cars, Mr. Chatterjee, not five.
10 cars.
Five
100 per day. 10
five
into 10.
two-wheelers and 10 cars stroke van stroke minibus can be parked on the said street, full stop, even if it is construed that all construed that the capacity of vehicles is parked on the said side of the road on a day, the total amount collected by the appellant would not reach rupees 1200, which is claimed by the defendant stroke respondent number 1 to have been paid by the plaintiff stroke appellant. For some next para, moreover, it is pointed out that the learned trial judge proceeded on a patently erroneous premise by observing that the day lot, what is this called, Mr. Chatterjee? The day lot, that job card. Thank you. The job cards indicate that an amount of rupees 1200 was being paid per day by the appellant. First, learned counsel points out that the job card, that is exhibit 18, which was relied on by the learned trial judge, is in respect of the western side of the Jogendra Kobiraj road, and as such is not applicable to the eastern side of the said road, which is the subject matter of the present suit. For the next para, learned senior counsel for the respondent opposes such prayer. Learned counsel for the respondent number 1 opposes such prayer, and it is pointed out that the amount of rupees 300 was being paid over a period of several days and not per day. Footstep in any event, it is argued by the respondent number 1 that the plaintiff, having failed to pay the remuneration at the agreed rate, the learned trial judge was justified in vacating the impugned order. Footstep next para, upon a perusal of the impugned order, we find a patent error in reasoning therein, inasmuch as the learned trial judge, inter alia, relied on exhibit 18, which is a job card in respect of the western side of the concerned road, and as such could not be germane for the present purpose, which relates to the eastern side of Jogendra Kobiraj road. Footstep next para. However, we find from the averments made in the plaint of the suit by the plaintiff stroke petitioner, plaintiff stroke appellant herself, in particular in paragraph numbers 10 and 11, that admittedly the plaintiff, having requested defendant number 1 to allow her to operate as the collection employee of the fee parking zone at Jogendra Kobiraj row within bracket eastern side bracket closed, the suit property, upon payment of daily fee of rupees 640 per day, the defendant number 1 orally entrusted the plaintiff to operate as the collection agent temporarily on and from 1st January 1 to 2021 at a daily fee of rupees 1200 payable by the plaintiff to the defendant number 1. First stop, it is alleged therein that the authorities assured that the plaintiff would be appointed on a permanent basis upon payment of daily fee of rupees 640 per day at a later stage after peaceful discussion, which never came to be, as the plaintiff was allegedly coerced to agree to pay rupees 1200 per day as demanded by the defendant number 1 at the time of death of her husband. Next para, learned counsel also insinuates that due to her condition, financial condition, the plaintiff being a widow with one minor child at present, cannot meet the exorbitant amount of rupees 1200 per day, keeping in view in particular the limited number of cars which can be parked, fetching a remuneration below such amount. Next para. Be that as it may, in view of the clear averment in the plaint that the plaintiff had agreed to pay initially at the rate of rupees 640 per month at a later stage, which never materialized, and the plaintiff was compelled to agree to pay rupees 1200 per day, comma, we cannot permit the plaintiff to resile from such position at this stage. Full stop. The said averment in the plaint was categorically in respect of the eastern side of Jogendra Kobiraj Row, comma, since the subject matter of the suit itself was the said property. Full stop. Next para. In the order, in the previous order of the division bench, dated February 17, 2025 at the ad interim stage, comma, it was categorically made clear that the injunction granted was subject to the condition that the appellant shall go on paying the remuneration as fixed by agreement between the respondent number 1 and the appellant to the respondent number 1 for collection of parking fees from the eastern side of Jogendra Kobiraj Row. Full stop. Next para. Read in conjunction with paragraphs 10 and 11 of the plaint, comma, as narrated above, comma, there cannot be any manner of doubt that the last agreed rate was rupees 1200 per month, and in default of the same, comma, by virtue of the said order of this court, comma, the interim order of injunction stood vacated, comma, which was merely granted the seal of court by the learned trial judge in the impugned order. Full stop. Hence, comma, we do not find any illegality in the order impugned herein. Full stop. Accordingly, FMAT 433 of 2025 is dismissed under Order 41 Rule 11 of the Code of Civil Procedure. Can 1 of 2025 filed in connection therewith is consequentially dismissed as well. No address to court.
One thing, well, five cars stands from page 26. Page not the.
Yeah, what did you say? Per month যেখানে যেখানে বলছে per day হবে।
Well,
এখানে
the
ঘুরতে
other
ঘুরতে
thing, well, the learned court has held that I was paid salary all along. I was not. I said
not
so.
going into that. We directed you to pay as per agreement. You did not pay. One. What about the next appeal? Yes, Mr.
The
Chatterjee.
next appeal is against an order of status quo.
They have filed. Mr. Chatterjee's client has filed a suit.
The Chatterjee's client has filed a
Yes,
suit.
obviously, not right.
Yes. On basis of the document at page 127. So this is the second one, item 17.
ওটা প্রথমটা হলো হ্যাঁ 16 it is 127 Mr. Yes.
But I say, Malad, this could not have been issued if it had been in existence, at least maybe not before my Lord's court, but in the numerous pleadings filed, the application under Order 39, Rule 4, the written statement.
Bora Bazar Society never pointed this out.
No. In the affidavit in reply filed to the app. And
the
one
date
other
says
thing,
January 1st, 2025. When was your suit filed? Your suit is of
2024.
24. So the ad interim injunction which we granted is even prior to this.
Is February 2025.
No, that is February 25. But
before
we were sitting in judgment over an order which was passed before this date.
Yes, yes. And the pleadings came.
That has merged in.
The 39-4 file was filed after my Lord's judgment.
They never spoke about
Never, no whisper. The other thing, Malad, very interesting, Malad, kindly sees page 127.
Yes.
Page 127 I showed. So the next page, Malad, 128.
All this is eastern side also. I mean.
They now say it's eastern side.
All along it's eastern.
Western side is there. There's Zamindari is there. But page 128.
East is east and west is west.
Is the job card.
Yes.
Which was annexed. But it was prepared with a view to filing of this application for addition of party. This is actually an annexation to the addition of party filed in the my suit. But Mala kindly sees page 120 now.
120.
This was sent on the speed post, because this application was sought to be put up on 1st November.
This is
a letter dated 29th October.
Order 1 Rule 10 filed by Mr. Chatterjee's client or the plaintiff?
Mr. Chatterjee's client.
You filed.
My 1st October, 29th October 2025. So naturally, Malad, at page 128, the last two dates had to be scribbled out. 29 and 30. This I say to persuade my lord to
29 and 30
it was a pre-ordered document, but since it had to be served on me by speed post before the end of the month, 29 and 30 was scribbled out. This
till the other entries remain.
The other entries remain, but that shows that this is a document created for the purpose of the suit. Along with the manufactured
document was not, the rest of the document was not created for the purpose of the suit, Mr.
I
Chatterjee.
say the entire,
Last two entries were deleted for the purpose.
entire thing. Now, a
Just
letter,
put the date of the letter only.
29th October. It was posted on 29th
No,
October.
but how does it make a difference? Because
the job card was prepared with a view to filing on first. I have the original certified
maybe
copy.
the job card as well as whatever else was prepared for the purpose of this
Yes,
authorized
but
letter.
now that it has to be
It may very
posted,
well be.
It has to be
because they have never disclosed. They never disclosed. Bora was never disclosed this about this.
Never ever. And my lord sees, kindly compares their addition of party application.
May I just clear this?
No, obviously their addition of party there will be similar to their own
Kindly see
suit.
the contradiction there.
Oh, there's a contradiction.
Yes.
Where is that?
The separate addition of party application.
Here, in this
Yeah,
court.
in my lord's court.
Earlier matter.
In the earlier matter.
What is the contradiction? Tell us. We can't look into it because you have
I'll
dismissed application.
read out, my lord. Here, my lord, page 123 in this petition, page 123, paragraph 6. Page 123. Page 123 of this application.
This means 17, item 17.
Yes. Your applicant states that the defendant number 1 on January 1, 2025 appointed your applicant as a fee collector.
No. Which paragraph?
Para 6 at the bottom of the page.
Yes, please carry on. Fee collector?
At Jogendra Kobiraj Road on the eastern side and issued authorization letter and identity card. That since then your applicant had been collecting parking fees and paying. Now in the addition of party, they shift the date. They say that application is there before my lords.
We cannot go by that. That's a post facto application. Because we have to see whatever was there before the learned trial judge, Mr. Chatterjee.
This application is pending. I have annexed that.
We can only look at whatever material was there before the learned trial judge. We cannot look at an application for addition of party made in a different appeal which has already been disposed of. Suppose it's still, we have not yet dismissed. But let us, can we look into that? This is post facto. Suppose they make a mistake or make an error which is telltale in an application filed in an appeal in this court. That cannot be a test retrospectively for whatever was.
This I say only to embellish my stand that this entire thing is
whatever was before the learned trial judge, we are ready to look into it.
This was before the learned trial judge.
So they had filed an application for addition of party in your suit,
yes,
which is still pending.
Yes, I beseech my lords to compare this paragraph with the paragraph 21 of the addition of party application that is filed here. It would be can 2.
The application is required.
Can 2. But this is the may I hand it over?
প্রথমটার ক্যান্টুর কথা বলছেন উনি প্রথমটার ক্যান্টুর কথা বলছেন সেকেন্ডটার না পেজ yes para 21 of this can itself
page 10
yes 2nd March
24.
Prior date.
This is what happens when one is making untrue statements. This confusion.
This also happens when one's advocate or someone midway.
If documents are created on basis of advocate's advice.
Go by this.
Anyway, Malad, there was no whisper. There was no whisper about this agent operating from the eastern side on basis of documents lawfully issued.
How did the learned trial just deal with this? You were heard on this.
No, this application is pending.
So what have you challenged here?
I didn't get it.
I've challenged the ad interim.
No, in the injunction you were, at the ad interim stage, you were not there.
No.
Let us see the ad interim order, impugned order.
Order dated 7th November. Then there is a incorrect recording.
Position, nature, and character in respect to the suit premises. But I mean,
that is what
you won't be able to demolish the road.
I will not be able to even walk.
Position, nature, and character does not even affect you. So this is not the position, nature. This is not
But
regarding the capacity to collect.
This order will be taken, Malar.
We will clarify that. Subject to the permission given by Mr. Anand Chatterjee.
And also the society's lawyer, learned lawyer.
But position, nature, and character don't disturb the position, nature, and character of the road.
But this describes.
You don't have, neither of you have, not even the society has possession of the road. It's a public
claims,
nature and character. We'll affirm this. We'll say position, nature, and character of the road cannot be changed by any of you.
But this order will be construed.
They should have challenged this order.
This order is
they should have challenged it.
will be construed as an injunction against removal of this
cannot be
plaintiff.
Cannot be. We'll say that it cannot be. Upon hearing them, we'll say that this is regarding position, nature, and character, not regarding either your or his entitlement to collect parking fees.
But he is collecting fees from the west.
This order does not affect you in any manner.
It
has to be regarding position, nature, and character of the eastern side of
collecting
that
fees
Koviraj
from the
road.
western side. If I am
Western, eastern, this does not affect you.
No, if I am allowed to park from the eastern side, well, heavens will not fall. I can sustain my family of 3 unmarried daughters.
That we have already refused in the previous one, we think.
I was.
That we have already refused.
This
Which
is a
you
review petition.
on verbal review. Yes, Mr. Chatterjee, what sort of this injunction you have obtained? Status quo regarding position, nature, and character. We will clarify that this does not entitle you, either of you to, this does not pertain to either of you, your entitlement to collect.
Schedule is all fee parking zone at Jogendra Koviraj Row under Posta Police Station. It's not on the middle of the road. It's on the zone where it is being collected. And if your lordship looks to
zone is a physical area.
Area. That it's on
that zone.
That's the area.
Position, nature, and character does not. And how can you be entitled? They never took this point before in the other suit.
That is why my review. That is why I filed the review, showing below
review.
Informing your yes. Your lordship's last order, my lord, I filed a review application where I wanted to come and tell your lordship, my lord, that I was given this in March 24. That's why my learned senior friend.
But here you have pleaded otherwise.
No.
From some other
haven't. Have a look at paragraph 8. My learned senior friend showed your lordship only the 10th paragraph. Sees paragraph 8. We've given the January date as well. Initially, my lord, it was in March 24.
But this is the only authorized letter you.
No, that is the authorization letter, my lord. Thereafter, what is this? Well, may I ask this question to myself? My lord, they have the right to collect. They do not do it physically. They give it to somebody like I don't cook. I have a cook, my lord, to cook my food. It's a similar way. They have a right to collect. They are not collecting. They're appointing me to collect. And for that, they're giving me wages with whatever in the form of a commission. That's it.
But
no, let him finish. Yes.
And these are all on temporary basis. Looks to the letter of the.
No, letter of authorization says.
Temporary. It's given to me.
Yes, but the date given is of a subsequent date.
No, January 25 was later, my lord. Was not, my lord.
So you have not produced anything to show that it was given to you on that date, that March.
There's a paper. There's a paper.
There is.
There is a paper.
In the intervener application, there is.
Of a previous date also.
Yes, all throughout. Lord, what happened was the vindictiveness your lordship was trying to, my learned senior friend was trying to say, my lord. Every lawyer, my lord, who appears has a criminal case behind him.
Has?
A criminal case filed against him.
In this matter?
Yes.
Lawyer?
Yes.
You?
But don't give ideas, my lord.
Yes, Mr. Chatterjee.
Do not give ideas.
I don't think that's right. No. I
don't give
with
ideas.
authority. But so far as this
that there is a personal fight, maybe, my lord, between the parties. I'm not even asking your lordship to get into that.
But how can you get an injunction that will prejudice their suit? They did not disclose at any point of
My lord,
time.
that
You are
is-
claiming through them only.
This is why I was not a party there. My part of the story was not there.
And this injunction could not be heard without hearing. If it is to be construed as what you are
Today I
impressing
have the
upon.
right to collect. If he goes and my lord,
No, he has filed a previous suit there. You are claiming through this Barabazar, who have not disclosed in that suit.
my lord, they,
Now, you
that
may have
is
a
why-
case, but they have to be given a hearing, and after that only.
let them be.
At interim stage, they will say that this cannot be construed as an injunction. This is the injunction you prayed for.
No,
Let us see the injunction you prayed for. That would be more interesting. To us.
but the injunction application is annexed.
89.
No.
It's at page
Yes, exactly.
89.
Page 94 is the prayer.
My lord, 94 is the
Temporary injunction restraining them and their associates from disturbing peaceful right, title, interest, and possession and use and enjoyment of the plaintiff in respect of the suit premises.
Yes. It could have been drafted a little better, but if your
So-
lordship sees
so
the
could have been my
entire-
plate.
Entire my lord, the paragraphs.
And schedule of the suit is all fee parking zone. Fee parking zone is a physical area.
It's a physical area. My lord,
So go and enjoy your title, possession, and whatever. We'll make this absolute, but we'll say this does not pertain to your entitlement to collect.
entitlement to collect, my lord, comes from them.
There is no injunction today as regarding your entitlement to collect.
They have, my lord, if your lordship doesn't make that comment, I have got no problem.
So we will make that comment.
But if that comes in, my lord, because they are not saying, my lord, that I'm not
And-
entitled to collect.
You are not entitled to have an injunction or status quo regarding right, title, possession.
No, that's a different aspect.
No, that is the impugn order.
Coming to your
We'll set aside on that ground.
my lord, your
You, even if you claim on your prayer that you are a collector of parking fees, you are not entitled to status quo regarding position, nature, and character in respect of the suit premises.
May I explain this, my lord? If your lordship may always mold the relief, whatever has, my lord, been asked.
Let the trial court mold it, but we.
My lord, trial court molds it.
This order does not stand.
My lord, your
You are not
lordship,
entitled to this.
my lord, your lordship, no, it's not for me, my lord, to write the judgment. It is not for the
No, no, it's on your prayer.
My prayer is
It's a
I tell
replica
you,
of your prayer.
the entire thing. Whether I'm entitled to, my lord, collect or not.
No, that
They are
cannot,
yet to
without
decide.
hearing them, Mr. Chatterjee,
Yes,
there
they-
could not
they
be an
can't-
ad interim
They
injunction.
can't come and stop me from, my lord, from, my lord, collecting. They can't.
Even for ad interim, they ought to have
Lord,
been
kindly
given a
appreciate.
notice. No.
Today, my right flows from Boro Bazar. Boro Bazar has given me a right to collect. Today,
Boro Bazar never said that in the other suit filed
that's
against
because
them.
my
You are
review
claiming through
application-
them.
My review application is for that.
Your review may be pending, but Mr.
File the review application to take the
Review in
lordship
this
back.
court, in this court.
In this court.
But in the suit, we are speaking about the prior suit filed by him. Boro Bazar never took this point.
Not in the written statement.
Nowhere. Not in the
application
statement
and
written
order-
objection. Nowhere.
Rule 4 nowhere.
No, no.
Lord,
You
there-
think Mr. Chatterjee would be the other Mr. Chatterjee would be sitting tight if there was some averment?
What I'm trying to say is very different. Lord, that suit was vis-a-vis his right. There, my right, Lord, doesn't come into play at all.
You are claiming through Barabaza. Barabaza never said, whispered that any other right was created.
Does that, in my respectful submission, my lord, take away my right?
No, but that does not. But if you have a right, they are required to be heard. They had a prior suit where Barabaza did not disclose
That's
this.
exactly what I'm trying to
They are
say, my lord.
they will be
They had a
directly
right.
affected.
They had a right.
It would be a contradictory injunction. Mr. Chatterjee, we are saying this. Ad interim injunction was vacated because they have failed to make those payments.
That's because, my lord, they
Now
didn't even
that
collect-
injunction application is still pending prior to your suit.
Yes.
They may very well get an injunction. It will be a conflict of decisions if ad interim is granted to you.
Both of them, my lord, would be heard together.
We will direct that, but
Right
at this stage, therefore, no ad interim injunction can be granted.
Now, what happens to my right? May I ask
We
you a
already
question?
had an ad interim injunction, which is contrary to your relief.
To my plaint.
Only because of non-payment, it has been vacated, Mr. Chatterjee. He had an ad interim injunction.
Beloved, that ad interim injunction, beloved, I was trying to challenge it before your lordship, and that period where your lordship granted that injunction.
Well, that review is still pending.
Yes, I did collect money because of that injunction.
No, Mr. Chatterjee, we will set aside this. Position, nature, and character, you cannot ask for
I bow down to that part
this
of
form.
the matter.
You go and file another injunction application and
Kindly
we'll
comes to
direct
my
them to
plaint.
be given notice before.
Comes to my plaint once, your lordship goes to the above and thereafter. Lord, it's not for me, my lord, to really, my lord, get into
Going by your temporary injunction application, this must be the permanent injunction which you have sought in the suit. I'm assuring you.
Yes.
Just go by your plaint.
Yes. But at the same time, page 81. kindly have-
85.
85.
Read. A is declaration,
A.
sole fee collector.
Yes.
Read B.
Only on that.
No, the permanent injunction, read it. This is in aid of that.
Based
Without the
on
permanent
it,
injunction?
it's based on aid. Milord, my right,
Yes, what is based on it? Let us read it out.
a degree for declaration, the defendant, including the men and agents associates, have no manner to disturb the peaceful right, title, interest, possession, use, and enjoyment in respect of the suit premises situated at. That's the free parking zone. At Jogendra under Posta, which is more fully described.
And disturbing peaceful possession,
Permanent
right?
injunction restraining the defendants, including their
This sort of an injunction cannot be granted to you.
No,
You are not the owner of the road.
no.
Neither is
I'm
Bada
not on the
Bazar.
road, but on the collection. On the collection
Your
of
injunction,
someone.
get a collection
That
in
is it.
order, but that will have to be done by
That's it.
upon hearing them.
You know what happens in the interact, Milord, becomes difficult. If she comes up every day, Milord, and disturbs.
Let some people park there without being charged fees for some days. Let them have some respite.
Loses out on. Boro Bazaar loses out on.
Even Kolkata Municipal Corporation loses out.
Exactly.
Let some people
day,
park for free.
Milord, every day I'm putting in the
You
money.
cannot get an injunction of this sort.
Putting in the money.
Prior injunction application, your order 1 rule 10 is still pending there.
In that suit.
That's pending.
Yes.
You know about that suit.
Yeah,
And if go and get an injunction in a different suit, expert.
That was fell from your lordship at one point of time. That in his suit I can't get a relief. Kindly appreciates.
Mr. Chatterjee, you have heard, no further
No.
hearing. And yes, if you want to add, please, Bada Bazar, what do you want to add to it? You never spelled out their rights being created. In the other suit?
Yes, kindly have a look at 107.
You have stated. In that suit, previous suit.
Yes, that's what I was surprised. 107.
That you came to know just now.
No, 107.
You came to know just now.
Doesn't matter. As long as I've come to know.
107, which part? Which paragraph?
Written statement.
107, which paragraph? What is this 107? No, in this one. You have got a 433.
Yes, suit Milord Boro Bazaar has told about me.
Let us see.
107 of 2024.
107 page.
Title suit number 507 of 2024. Recently stated, they are in effect.
That we know. What about the first suit? What was your defense in the first suit? Did you tell the court? In the previous suit, between you and them, did you say in your written statement that you have created a third party right? Where is that?
But they have said, Milord. It was not for the Boro Bazaar to say. The plaintiffs have said.
Where?
Luke takes up below the other one. Other appeal. 433.
Yes, which page?
Page 108.
This is what?
Starts off from below 106.
This is an opposition of the plaintiff.
Yes. Filed in the order 39 rule 4.
Yes, where have they said?
Kindly have a look at below 108, second paragraph. In this connection, it is stated that a maximum of 6 average size vehicles, wheelers, can be parked on such and such, which is where parking is legally permitted by Kolkata Municipal Corporation, and which is the subject matter of the injunction passed by the Honorable Division Bench. Huge resistance is faced by me at the hands of men and agents of defense number 1, particularly one Dilip Shonkar, helper, that's me, helper of my deceased husband in collecting parking fees.
No, this is different. They are saying that you are disturbing
That is my consistent case.
They have not stated that they have created a right in your favor.
Physical abuse.
In my written statement, I have categorically stated that
এটা কোথায়?
lady is only a collecting agent or employee appointed as the defense.
Have you stated that Dilip Shonkar, you have created a right in favor of Dilip Shonkar? We are dismissing this appeal, Mr. Chatterjee, on the observations we'll make. The present appeal has been preferred by
Dismissing the appeal.
Dismissing, but we'll hold that this injunction does not create an entitlement. This appeal has been preferred by the plaintiff in a suit for declaration that the plaintiff has entitlement to collect parking fees in respect of Jogendra Kobiraj Row within bracket eastern side, comma, granted by the Boro Bazar Fee Parking Cooperative Society Limited, comma, the pro forma defendant stroke pro forma respondent herein. Full stop. Next para. By plaintiff in a suit bollam. The present appeal arises out of the grant of an ad interim injunction in favor of the plaintiff stroke respondent number 1. Full stop. Next para. In the said suit, comma, the respondent number 1 claims to have been granted car parking fees, rights to collect car parking fees in respect of the eastern side of Jogendra Kobiraj Row by the pro forma defendant stroke pro forma respondent, namely one Barabazar Fee Parking Cooperative Society Limited. Full stop. Next para. It has been contended by the plaintiff stroke respondent before the trial court that such rights were being disturbed by the defendant stroke present appellant, comma, whereupon an ad interim injunction has been granted as prayed for. Full stop. Next para. Learned counsel for the appellant contends that in view of the pendency of a prior suit at the behest of the present appellant claiming similar rights in respect of the self-same car parking zone, comma, in which an ad interim injunction was granted by a division bench of this court, comma, the said ad interim order could not have been passed. Full stop. Secondly, comma, it is argued that the Barabazar Fee Parking Cooperative Society Limited, comma, through which the present plaintiff stroke respondent number 1 claims its rights, comma, never took the plea that any such car parking fee collection right has been created in favor of the plaintiff respondent number 1 at either in the written statement or written objection of the said society in the earlier suit. Full stop. Next para. Thus, comma, it is submitted that the impugned order is bad and ought to be set aside. Full stop. Although at the admission stage, comma, we granted right of hearing to the learned senior advocate appearing for the respondent number 1 in order to ascertain the version of the said respondent. Full stop. Next para. Learned senior counsel submits that several documents have been produced to show authority has been granted in favor of the plaintiff stroke respondent number 1 by the pro forma respondent for collection of parking fees in respect of the car parking zone in question. For some next para, not only that, comma, the present plaintiff stroke respondent number 1 also applied under order 1 rule 10 of the code of civil procedure for being added as a party to the previous suit filed by the present appellant, which is still pending. Push up. Next para. Learned senior counsel argues in addition that an application for review of the ad interim injunction order passed by the division bench of this court in the earlier suit at the behest of the plaintiff stroke respondent number 1 is still pending on the very premise that the rights created in favor of the present plaintiff stroke respondent number 1 were not considered by the said court. Full stop. Next para. Thus, comma, it is contended that the injunction order, ad interim injunction order granted in favor of the appellant, in favor of the plaintiff stroke respondent number 1 was justified. So next para. Upon hearing learned counsel for all the parties, comma, we find that, comma, indeed, comma, the society within bracket pro forma respondent number 2 herein bracket closed, comma, under which the plaintiff stroke respondent claims its right of car parking fee collection, comma, never pleaded either in its written statement or written objection in the prior suit filed by the present appellant as regards any right having been created in favor of the plaintiff stroke respondent number 1. Full stop. Next para. That apart, comma, the manner in which the temporary injunction application has been couched in the present suit by the plaintiff and the ad interim order was granted does not pertain to the collection of any of the parties to collection of by any of the parties of parking fees. Full stop. The prayer as well as the language of the ad interim order impugned herein is that a status quo, an injunction within bracket in the form of status quo in the order bracket closed regarding possession, common nature and character in respect of the suit premises has been granted for a limited period. Full stop. Next para. The description of the suit premises in the plaint and the injunction application is within double inverted all fee parking zone shop cafe at Jogendra Kobiraj Row within bracket eastern side bracket closed, comma, under Posta police station in the district of Kolkata hyphen 7 lakh 7. Full stop. Next para. Double inverter মধ্যে fee parking zone double inverted clause is a physical location and the plaintiff stroke respondent has not claimed in his suit any right, title or interest of possession, comma, and or in respect of the corpus of the said property. Full stop. As such, comma, the status quo granted by the learned trial judge was in any event misconceived. Full stop. However, comma, keeping in view that the said order does not affect the rights of the present appellant or for that matter the plaintiff stroke respondent number 1 in respect of collection of car parking fees, comma, which is the primary bone of contention between the parties, comma, we do not find it worthwhile to interfere with the impugned order in any manner. Full stop. Next para. As such, comma, another aspect of the matter cannot be overlooked. Full stop. In the event an interim order was to be passed by the learned trial judge affecting the rights of the present appellant of car parking fee collection, comma, it would only be appropriate to give an advance notice and give a right of hearing to the present appellant prior to passing such an ad interim order. Full stop. Next para. We say this because independently of pendency of a subsequent review application at the behest of the present respondent number 1, comma, fact remains that an ad interim order of injunction was granted in favor of the present appellant in the earlier suit filed by the latter, comma, protecting the rights of the present appellant to collect parking fees from the zone in question, comma, which is also the subject matter of the subsequent suit from which the present appeal emanates. Full stop. Next para. The said ad interim order was vacated subsequently and affirmed by this court only on the ground that the condition thereof, that is payment of due remuneration as per agreement, was not made by the appellant. Full stop. However, comma, since the said injunction application in which the ad interim order was initially passed is still pending in the trial court in respect of the appellant's suit, comma, it would be utterly inappropriate to pass a contrary injunction in favor of the present plaintiff stroke respondent number 1, comma, ad interim or otherwise, comma, which would create conflict of decisions and judicial anarchy. Full stop. Thus, comma, in any event, comma, we construe the impugned order to be one pertaining to the.
In their suit, the injunction is not pending.
That was ad interim.
No, it has been disposed of.
Mr. Chatterjee, you said it was ad interim?
My lord's order was ad interim.
Then it was disposed of.
That injunction, no, they came up against an ad interim refusal.
They came up
The injunction application is rejected.
বুঝতে পারলাম না।
Last paragraph তাহলে যেখানে injunction has been allowed করে দিচ্ছি ওই জায়গাটা moreover করে
The
যেখানে
entire thing
বলেছি
should change, Milord, if your lordship
no
was on that
moreover করে ওটা বাদ দিয়ে
frame of mind.
না
That observation kindly
has been rejected.
Milord,
ওই
that
সেন্টেন্সটা একবার মিস্টার চ্যাটার্জি প্লিজ সেন্টেন্সটা এই সেন্টেন্সটা কেটে দাও. However, since the previous suit filed by the plaintiff claiming self-same rights over the self-same property is still pending, comma, despite the subsequent rejection of the temporary injunction application of the appellant in the said suit, comma, the bone of contention and cause of action in respect of bone of contention and issues involved in both the suits are similar in nature. Full stop. Accordingly, we direct title suit number 2474 of 2025 pending before both are before the 12th bench, pending before the 12th bench of the City Civil Court at Calcutta to be clubbed and heard along with
Yes, 507.
Yes.
That
heard with
would it be
507 of 2024.
may I
Title
intervene
sheet
a
number,
little bit?
title sheet number 507 of 2024, 2024, along with the connected interlocutory applications. Yes, Mr.
My lord, their suit is at the framing of issue stage, and my suit is, my lord, at the injunction stage. So now my injunction needs to be heard out, my lord, before, my lord, the other issues.
No, we said along with the
Say, my lord,
connected interlocutory
from the-
applications.
Once the interlocutory applications are all over, then, my lord, it can be clubbed together.
No, we are clubbing those together. We have said along with the connected
This
interlocutory.
injunction application to be heard out immediately. They have to file an opposition. I have to file a
But
reply.
it is expected that the interlocutory, that the injunction application from which the present appeal arises shall be heard expeditiously by the learned
being
trial judge
influenced. Without being influenced by the
upon granting a reasonable opportunity to the present appellant to file written objection thereto, preferably within 6 weeks from the date of communication of this order to the said court. Full stop. It is further clarified that all the above observations have been made. All the above observations are of a tentative nature, made for the limited purpose of adjudicating the present appeal, and shall not in any manner unnecessarily prejudice the learned trial judge at any further stage of the two suits, be it at the interlocutory stage or the final hearing of the suit.
Like, one place your lordship has written rights in the property. That your lordship may kindly, there's no property here, right for collection.
We have said that right of this injunction means right corpus, rights in the corpus of the property.
Well, in the first order also, my lord, add that, my lord.
Injunction is always there.
হ্যাঁ ওটাও হয়ে যাবে consequently dispose of
But-
এটারও করে দাও
In item 16, my lords also add that protection, but that the observations of my lords will not.
dismiss যেটা বলে under order for 10 rule
দরকার নেই
আর
দুটো,
can
একদম।
1 of 2025
ওটা না-
is accordingly dismissed as well. ঠিক আছে এটাতেও dismissed as well. আচ্ছা যেটা লাস্টের প্যারাগ্রাফটা দিলাম না এই যে observations made above are tentative in nature, ওই সেম প্যারাগ্রাফটা ওনার অ্যাপিলটাতে হবে
Item 16.
same last observation will be in their appeal.
I was wondering
that the Borobajar Society is not precluded from collecting parking fees.
Why should you say that? You have not been
They are all along hampering our collection.
nobody is disputing. They are claiming through you. Both of them are claiming through you. How is your right affected? You go and directly collect now. Yes, Mr. Chatterjee.
No,
We are not putting that in order.
No, what I was wondering was, I had an order 1 rule 10.
Kindly make it clear.
An order 1 rule 10,
Humble prayer.
No,
We
no,
are
nothing.
really collecting again.
Order 1 rule 10 was pending. That can go.
Item number 18.
Well, at 18, my lord, we need to file an application under section 5. My lord. There is a delay, my lord.
Counsel for the appellant seeks leave to file an application for condonation of delay in preferring the appeal. Full-stop. Accordingly, let the matter go out of the list with liberty to the parties to mention the application as and when the same is filed.
Item 19.
19, my lord, I appear for the appellant, Mr. Bhattacharya. Vikas Ranjan Bhattacharya is leading me.
Yes. What is the
He
matter?
Told that he would be in online.
He's not there, so you start.
My lord. My lord,
Subsequently, did you obtain the certified copy? Because we gave you leave.
Today, at 5:30, I will get it.
Very well.
My lord.
As
As my clerk has told.
leave is granted to the appellant to file the certified copy of the impugned order as and when the same is obtained by the appellant.
Yes, yes, I shall.
Yes, move the matter. Yes, what is the matter?
My lord, I have come before your lordship against the order of refusal of interim order. That is at page, my lord, 145. Matter relates to, my lord, the State Bank of India Staff Association.
Yes.
A meeting was convened by the Deputy Chief Secretary, ignoring the authority of the Chief Secretary and challenging such notice and the subsequent meeting, the suit was filed. And in aid to the said suit, my lord, injunction application was filed and moved. That was refused.
Who are you?
My lord, I am the Chief Secretary.
So, who called the meeting? Who convened the meeting?
Deputy Chief Secretary convened the meeting, ignoring the rules and regulations of the State Bank of India Staff Association.
Why was the injunction refused? Ad interim or temporary injunction application itself dismissed?
Yes,
temporary. So why refused?
Well, refusal on the ground of, my lord,
Yes.
they have said that the subordinate court, with an observation that the meeting is valid because of, my lord, there are certain allegations against me. And since the allegations, observe that allegations are serious allegations, that has been observed. That is the subject matter of the meeting. Since the allegation against me, I was not eligible to conduct the said meeting, and that's why the Deputy Chief Secretary, ignoring the rules and there is specific rules and regulations who would convene the meeting. Without following those, my lord, the Deputy Chief Secretary convened the meeting.
They filed written objection to your injunction application?
No, that has not been.
Even in the impugned order.
So, this is an ad interim refusal.
My
not
lord, ad
temporary.
interim. No, ad interim. And my lord, subsequently what happened, on the basis of the said meeting, my lord, they are continuing the perpetual wrong. And that is affecting the entire association, including the Chief Secretary. My lord, before your lordship, my lord, I will show what is the notice first, my lord.
Yes.
My lord, notice is at page 102.
Yes, 102.
Well, notice dated 14/10/2025. The meeting for Central Executive Committee. There is a hierarchy, my lord. The Central Committee, Central Executive Committee, Circle Committee. Central Committee is the Apex Committee, my lord. And the Circle Committee is the State Committee. And the lowest is the, my lord, Unit Committee. And this is the meeting of Central Executive Committee. Central Committee, thereafter the Central Executive Committee. I will show your lordship from the rule, my lord. That is the hierarchy. That is at, my lord, page.
No, this was regarding complaints against you only. This meeting was convened. The first agenda is complaints
My
against
learned
you.
senior is online, my lord.
Yes, Mr. Bhattacharya.
But basically, the meeting ought to have been convened by the plaintiff if a meeting was sought. They say since there is a complaint against you, therefore a meeting is convened by a party who is not authorized under the rules.
But Mr. Bhattacharya, what would be that would be a peculiar situation. If the allegation is against you, you'd never convene the meeting.
Yes, that on this allegations agenda, convene a meeting. If I refuse to convene a meeting, there's a provision for requisition meeting. Nothing was done. Someone who is not authorized under the regulation convene a meeting. I say that they say yes, we did not ask you to hold a meeting. Might be that as an allegation against me. That allegation has to be discussed in the proper appropriate meeting. I have never said that since the allegation against me, I will not convene a meeting. That's the whole issue.
So
Let them-
you say, Mr. Bhattacharya, that there is an alternative option. Suppose the allegations are against you, so a requisition meeting can be
Yes,
convened.
if I do not convene a meeting, there
Right.
can be requisition meeting.
Let us just see the relevant provisions, Mr. Bhattacharya.
Yes, kindly,
First
kindly
that
come
you
to
have
the
to convene.
regulation.
Yes.
Yes. My learned junior plays the rule
Page-
52 at page 71.
71. Page 71.
Page 76, Rule 70, page 76.
Page 76. You are what? The
I am
secretary.
the chief secretary.
Chief secretary. This says the president will preside over meetings.
Rule 70 by 2.
Acha, chief secretary shall convene.
Shall convene.
Very well. And where is that requisition meeting provision?
Page mirrored 79. 75, Rule 75, 1 and 2.
That also chief secretary has to convene.
No.
No, the chief secretary may convene a special meeting and circle so and so to be dealt matters considered to be specially important in the interest of the union when they consider it necessary or on a requisition made in writing by at least 51% total number of the electoral college.
But that, Mr. Bhattacharya, does not make any difference. Still, you have to convene the meeting, the chief secretary.
No, yes, if I do not convene the meeting, then the requisitionist can hold the meeting. That's the provision 75. Will she kindly come to 75 II?
Acha, yes.
In case of non-compliance or valid requisition mentioned Rule 75(1), within 1 month from the date of receipt by the chief secretary, the general secretary of the concerned circle, as the case may be, the requisitionist shall have the right to convene such a meeting.
All right.
Therefore, this is not such a situation that if I sit over, there is no way out.
Yes. All right. All right. So let us just see the impugned order now in this context.
145.
The impugned order is very funny. I just showed the learned court, though did not pass any order in my favor, but said that since I am going to test the order before the High Court, he has asked the parties that you hold your hand. But they did not bother.
Let us see
Kindly
that.
come to the order impugned. The last part is very interesting. I am not going to the merit of the order, which are ultimately decided by the court.
Several allegations there are against you, which has been.
Allegation, I accept there are allegations, but that has to be gone into by the members in the meeting. Kindly come to the last part of page 150.
Page 150, second paragraph, court says, moreover, in my opinion, the plaintiff has
Yes, that
not
is the
paid out.
court. Yes, that is the court finding, which is wrong, I will show. But in that part, the next part is important. After dictating the aforesaid order, learned counsel of the plaintiffs had verbally submitted that as the prayer for interim injunction has not been granted by this court, but this court may direct the defendants not to hold the meeting of the Central Disciplinary Action Committee scheduled to be held on 19th November in order to enable the plaintiff to challenge the legality and validity of this order passed by this court before the Honorable High Court, Calcutta, also to enable the plaintiff to file a detailed reply to the charge sheet dated so and so. Learned counsel of the defendant has submitted that they can at best make a request to the effect that defendant number 2 not to hold the said meeting so and so. But this sort of decency, if I may use that expression, is not also carried out. They hold the meeting, they held me guilty, and then punish me. But I don't want to avoid a meeting. I want let there be appropriate meeting and let it be discussed whether I am guilty or not.
You have already been terminated.
Yes.
So now is the injunction relevant
Now
anymore?
that I would be praying for status quo ante following the judgment of this court. If it appears that they want to really make the entire thing frustrated, Lordship is well aware of the judgment that's in Honorable Kumar Sen. 1983, Calcutta.
1985, Calcutta, page
85,
248.
Page
248.
Yeah.
A judgment of place kore dao.
Yeah. I am pleased.
Give a copy of this.
Indian Cable Company Limited versus Srimati Sumitra Chakraborty.
But something they have alleged has been considered here before going to the judgment, Mr.
Yes.
Bhattacharya, that at page 150, moreover, despite convening this is their allegation, of course. Moreover, despite convening a meeting through notice dated such and such, the chief secretary, that is a plaintiff hearing, was given an opportunity to attend the meeting, but he chose not to attend. Therefore, also but this is not a specific request to you to convene a meeting.
Yes.
All right, all right. All right.
How could the deputy secretary convene a meeting?
And yes, which portion of this judgment, although Indian cable is settled,
Can
any
we come
particular
to-
portion? Yes.
Oh.
Indian paragraph 8 onwards.
You are very well prepared. You are very well prepared.
Grateful to Lordship.
I wanted him to argue the matter.
8, 9, 10.
No, you are there, Mr.
8, 9, and 10
8, 9, 10.
entirely dealt with, more particularly. পুরো এই 3টে প্যারাগ্রাফে পড়তে হবে না। মে আই রিড ইট আউট?
Yes.
Paragraph 8. I have carefully considered the rival contentions put forward before us.
Is an order to rule 2?
This is.
Yes.
The provision of order to rule
Because the
2
previous suit, this prayer was not taken there.
cannot be.
Yes, yes.
Cannot be.
That's on a different footing.
But different footing, but the whole purpose was it cannot really make entire thing infructuous by taking hasty action.
Just to stop the perpetual illegality.
Well, he was evicted, the person was evicted. Justice Shen restored him back.
This was on whether interlocutory relief can be, by interlocutory relief, the main relief can be granted. There it was
Yes.
clarification.
That's the point. Lord.
Nandan Pictures was
Dealt with.
Very well. Very well, Mr. This is all, Mr. Bhattacharya?
Well,
if both of you agree, we will dispose of the appeal itself. Unless you, Mr. Shen, you say something else. No, we'll hear you after hearing you. I mean, we are taking up the appeal itself for disposal.
Yes, yes. At interim stage.
That's why. We'll just record one line that we are admitting the appeal and taking up the appeal for hearing. Mr. Bhattacharya will do that because otherwise, either way we pass an order, the other side suffers. Yes. So, since questions of both fact and law are involved in the appeal, the same is admitted to be heard on the grounds taken in the memorandum of appeal. The appeal is taken up for hearing along with the connected application on consent of learned senior counsel appearing for both the parties. Yes, Mr. Shen.
Lord, may I proceed on the basis that Mr. Bhattacharya has no other provisions of the rules to show your lordship, and this is the only
resolve between yourselves and then.
Sir, আর কিছু দেখাবেন কি স্যার?
Provision আছে.
আর কিছু কি
There
দেখাবেন?
are provisions-
warning.
You are not here. I don't want to put you at a
No,
disadvantage.
no, you just show the rules if necessary.
reply will
reply
help.
as to try.
Show the other rules and then reply.
Number 14th of October 2025 was shown to your lordship. That is the notice for convening a meeting at page 102.
This is what has been challenged in the suit also.
What has been challenged?
Yes.
102. This is what was shown to your lordship.
Yes.
This is a notice issued by the Deputy Chief Secretary.
Right.
Question was whether Deputy Chief Secretary has the jurisdiction to issue such a notice. Not, I cannot show your lordship documents that we have with us, but I'll tell you substantial from documents on record for the time being. Now, Lord, the story starts a couple of days before that. Not, please bear with me for just 1 or 2 minutes. The story starts on 14th of, this may not be relevant, but not, it's relevant having regard to the circumstances that have evolved. Lord. 14 September 2025, a meeting of the Central Committee was convened at Ranchi by the plaintiff. Lord, members of the staff, these are Lord, employees of the State Bank of India. They are staff, Lord, they are not supposed respectable people holding high positions. So 14th October, when they went to the meeting at Ranchi, what they found, Lord, was that, if I may just show your Lordship.
This pleaded in the, oh, you have not.
I'll show your Lordship from documents on record to substantiate what I'm showing. Otherwise, I'm handing over. I won't hand up much. I'll just hand over to your Lordship.
The documents on record as in their annexures?
Their annexures. The suspension order refers to this. The charge sheet refers to this.
In our annexure.
The charge sheet refers to this, refers to this incident. This is what they found. This is what was found. This is what was found. This is at the meeting convened and organized by the plaintiff in Ranchi on 14 September 2025. Armed people roaming around with assault rifles. Protection being given.
We cannot look at these at
at
this stage, Mr. Sham, because these are not on record and at this stage you have to proceed
correct.
on the premise that their allegations, on the basis of that whether we can grant it.
The gentleman in blue is a plaintiff.
Is a plaintiff.
The gentleman in blue is a plaintiff, and the gentleman in red is the person he is supporting. Now, this was the situation. As a result of this situation, my lord, complaints were received from all the circles, saying that we have been heckled, we have been threatened. There's a chaos, an atmosphere of fear has been created, and the entire proceedings have been vitiated.
This is for what? For the purpose of holding an election or something?
This is for the purpose of taking various administrative decisions with running of the organization. No election was scheduled on that day, but various important administrative decisions were to be taken.
So what could be the purpose of the plaintiff of showing his strength? I mean, for what?
To ensure that his whatever he wanted gets passed, and nobody has
the red colored person is not an official of the. He is
also
one of them.
Now, Lord, your Lordship will find some of these complaints are in your Lordship's brief note at page.
But there are several complaints we can appreciate. Yes. But whether you have authority.
Yes, I'll come to that. Look, page 126, 128, 129. These
allegations is an admitted position. Mr. Bhattacharya does not refute that there are allegations.
Right.
Although he refutes the allegations of
this becomes important in the backdrop of what now I will submit.
Yes.
So these complaints came by central committee members of different circles, saying that these are allegations against the plaintiff, who is the chief secretary, of him having conducted acts of omission and commission, misconduct, misdemeanors. Therefore, please take steps against him. And Lordship, these are the documents which are not yet on record, but I have with me, by which these circle secretaries, they communicated that for such a meeting, it is necessary to appoint the deputy chief secretary to take steps. Now, the question which I will be faced with, can this be done? If it cannot be done, it cannot be done. Not in my respectful submission, it can be done in terms of Rule 70. If your Lordship kindly comes to Rule 70.
Yes, 70.
Rule 70, your Lordship will find, I'm sorry, not Rule 92. Rule 92, if your Lordship please comes to at page 86.
Yes.
If in the opinion of the President and the Chief Secretary, any of the office bearers, Vice Presidents, Deputy Chief Secretaries, General Secretary, Assistant General Secretary, Circle President, General Secretaries have done any act prejudicial to the interest of the Union, Lordship will find that the plaintiff as Chief Secretary is not covered by this 792, the first portion. If in the opinion of the President and the Chief Secretary, Vice Presidents, Deputy Chief Secretaries, General Treasurer, Assistant General Treasurer, Circle President, General Secretaries. So misdemeanors with regard to these posts, not the post which the plaintiff was holding. Then Lordship, please comes to the next page, Roman 7.
Yes.
In case of Chief Secretary, that's where the plaintiff comes in. In case of Chief Secretary, if the Central Executive Committee is of the opinion that the Chief Secretary has committed any act prejudicial to the interest of the Union, Union means the organization, Union or brought disrepute to the Union, the Deputy Chief Secretary, so authorized by the Central Executive Committee, will refer the matter to the Central Disciplinary Action Committee. which will authorize any office bearer as a substitute of Chief Secretary to draw, frame charges and issue charge sheet and adopt procedure to be followed in other cases, then the usual procedure takes place.
But this is somewhat different from calling for a meeting.
No.
Deputy Chief Secretary can only that the Deputy Chief Secretary is so authorized by Central Executive Committee. I mean,
We'll refer the matter to the Central Disciplinary Action Committee.
so then first there has to be an authorization by the Central
Yes, Lord,
Executive
I have
Committee, which
those
is the
letters
top body.
I have those letters of authorization with me, which I will put in the affidavit in opposition. Each of the Lord, Central Executive Committee members have authorized the Deputy Chief Secretary to Lord, refer the matter to the Central Disciplinary Action Committee. Those letters exist, and it is on.
But that only authorizes you to refer the matter to the Central Disciplinary Action Committee,
which will authorize.
which will authorize any office bearer as a substitute of Chief Secretary.
Right.
But you do it yourself. If you please come to page 102, Mr. Shen.
Yes, Lord.
Just keeping in on the background the language of that.
Yes, Lord.
Now, here what you have done is you call for a meeting on the request of this much, you say you comply. Request of the Central Executive Committee members, authorization. Hereby given for holding Central Executive Committee meeting.
And the Central Executive Committee will take these decisions. Not that I've taken these decisions. This is the agenda. To place the complaints of the Central Executive Committee members against Abhaydev Sharma, that's the plaintiff, Raju Kumar Singh, that's the gentleman in red, and Priya Ranjan.
All right.
To discuss and authorize one office bearer, this is exactly in terms of
language
92.
of 7.
To discuss and authorize one office bearer as substitute of Chief Secretary to draw, frame charges and issue the charge sheet. So we followed the procedure. 3. To discuss and authorize one office bearer to act as Chief Secretary till the conclusion of disciplinary action. Exactly in terms of the rules.
Very.
So in terms of this notice, meeting was held on 23rd October 2025, which is the subject matter of
very well. So the rules confer power on you under certain circumstances, which in the impugned notice itself you referred to.
Yes, Lord.
You referred to, it's a matter of trial whether actually complied with or not.
Yes, Lord. Now, Lord, one more rule, if your Lordship please comes to.
Yes.
If your Lordship please has a look to Rule 16 at page 50.
Rule 50?
Rule 16 at page 50.
Yes.
When the Central Disciplinary Action Committee is being constituted, naturally, AK Kripak, one cannot be judged in one's own cause. That is in the note here. The members of the Central Disciplinary Action Committee against whom the disciplinary action is initiated will be excluded from the said committee. He cannot be a member of the committee because he is the accused.
No, Secretary by ex officio, he's a member of the Central Disciplinary Action Committee.
He is, and then the note follows.
Oh yes, Chief Secretary.
No, Roman 2 is Chief Secretary, then the note follows.
Yes.
But if the charges against you, you can't be a member of the committee.
Rather, he cannot. Not that he's
basic principle of jurisprudence that we follow. So we followed the procedure. The court below has refused the injunction, saying the procedure is in accordance with law. I am not going to injunct the meeting on 19th of November. You make a request, try and settle it amongst yourselves. That's what Mr. Bhattacharya was showing your lordship, that the court said, I find that it's in accordance with law. I am not going to pass an order of injunction. The page which was shown to your lordship at page 150.
Yes.
The second last paragraph, last line, accordingly, prayer for interim injunction, relief of the plaintiff at this stage is refused. After dictating, learned counsel for the plaintiff verbally submitted as a prayer for interim injunction relief has not been granted by this court, but this court may direct the defendants not to hold the meeting. That was a request saying that I can't do anything, you all settle amongst yourselves. Our counsel said, I don't have the instructions, I can make a request to my client. That's not what the impugned order is. There's no infirmity in the impugned order.
One infirmity is that considering the fact that this court is not a writ court, therefore writ court even cannot do it. Anyway, so we'll ask Mr. Bhattacharya what is his reply.
Two other aspects of
Absolutely,
the matter, yes. Permits me. One is your lordship will find that the defendant number 1 who is named in the suit, Chandan Das, he is only the person who has issued the initial notice of 14th of October 2025. The prayers also challenge further notices which have been issued including my lord, the charge sheet. The charge sheet, your lordship will find
The
is
prayers in before this court or in the suit itself?
in the suit itself, in the suit as well as before your lordship. Your lordship will find the charge sheet at page 111. This is in terms of the authority conferred by the Central Disciplinary Committee to authorize one officer to take the process along in terms of rules 92(7). Now, this charge sheet has been issued, your lordship will find, by one Pankaj Kaushik, who is now the acting chief secretary, who has been authorized by the disciplinary
Central
committee
Executive.
yes, to take it forward. The
So
charge
non-joinder, you are arguing non-joinder.
I'm arguing non-joinder. And my lord, there are affirmance your lordship will find with regard to non-joinder. If your lordship kindly takes page 23, paragraph Roman 9 in the injunction application.
Yes.
Page 23, your lordship will find Roman 9. So the allegation is of against the person himself, that he is claiming himself to be the acting chief secretary. Issued a charge sheet.
Yes.
Then, if your lordship kindly takes the next page, page 24, last 5 lines of the first paragraph. Despite supersession, Pankaj Kaushik being General Secretary, Delhi Circle, claiming himself. And he is the person who has issued the charge sheet, on the basis of which action has followed. He has not been made a party to the suit. It's not a question of the corporate body having a right to sue and being sued. It's an action by him as persona designator. A proper and necessary party has not been implemented, and the orders are also being sought by way of injunction in respect of the charge sheet and action which has followed the charge sheet.
Well,
Lord, that's one aspect of the matter. And the last aspect, Lord, I won't take your lordship's time. Lord, so far as the notice is concerned, after 19th of November, Lord, I have with me, but it's not on record. The further action has been taken on 19th of November. On 19th of November, the plaintiff has been removed from his post as the chief secretary, and he has been removed from primary membership of the association itself. So today he is not a member of the association at all, of which he is aware. 19th November, he was aware because the impugned order refers to the meeting of 19th of November.
So how could I ever? The resolution has not been communicated to me.
The impugned order refers to 19th of October meeting. They should have applied by way of another application under Order 39, Rule 1 and 2.
How could the impugned order refer to that? You argued that. No, you were not heard.
If your lordship please takes page 150, last 3 lines.
How does that come in? You
But
were
the
not.
court made, that's a prayer. That's they know of this meeting. They knew of this meeting. Page 150, last 3 lines, part of the impugned order, which Mr. Bhattacharya read. But this court may direct the defendants not to hold the meeting of Central Disciplinary Action
That was
Committee
the
scheduled on 19th November, second last line. So meeting was held, decisions have been taken, it has been acted upon. There's no application for amendment of the plaint, no application for bringing further facts on record. And it's not also impugned anywhere. Even with regard to status quo ante, it has to be impugned. But finally, my lord, we are actually arguing a storm in a teacup. I just wanted to say this at the end. We are actually arguing a storm in a teacup.
Why do you say that?
Lord, if you're Lord, Regulation 8, Rule 8, if your lordship please comes. Your lordship please comes to Lord.
Yes.
Page 46.
Yes.
A member sees 8.1. A member ceases to be an employee of the bank shall not continue to be such member. 2. None but a regular member of the union other than chief patron will be allowed to hold a post.
He's not an employee of the bank.
Ceasing on 30th of November. 4 days left. 30th November is his date of superannuation, which your lordship will find in his pleadings at page 10. Page 10, paragraph 11, his pleading is there. And this fact is also recorded in the impugned order, the fact that he is to retire on 30th November. Your Lordship will find that at page 150 itself. Not the same page we are troubling Your Lordship with. The middle paragraph, about 7-8 lines from the top. In the facts of the present case, as granting the same would render all the proceedings against the plaintiff herein infructuous, as he is said to be retiring on 30th November 2025. Page 150, middle paragraph. Middle of that paragraph, plaintiff herein infructuous, as he is said to be retiring on 30th November 2025. Please, Toto. And he had replied to the charge sheet also, which was issued by the Deputy Chief Secretary. Had responded to the charge sheet.
That's in his pleading that he has replied.
That's annexed also.
Oh, good.
That's annexed here at page 130.
Charge sheet.
Charge sheet I showed your Lordship at page 111. The Lordship has a look at page 111. What I was telling your Lordship, which your Lordship said it's not on record, don't let me not take cognizance of it. The facts are pleaded here. Please come to page 111.
Yes.
Lord, please come to Lord page 112, serial number 7. You in connivance with Sri Raju Kumar Singh hired goons to threaten the Central Executive Committee members and particularly Shudip Dotto, General Secretary of the Bengal Circle, of dire consequences of the meeting of 13 such and such. On 14th, you in connivance with Raju Kumar Singh made mockery of Central Committee meeting at Guru Nanak High School auditorium when you did not permit any office bearer to preside the meeting. 9, you in connivance with Rajiv Kumar and Priyaranj hired goons who were illegally holding guns and threatened the Central Committee members. So this is on record. So several complaints have come, 4-5 of which are on record, yet filed by way of fealty before the trial court. Those are annexed here. And it's on that basis that action in terms of 92(7) was taken. These are
Yes, Mr. Bhattacharya, reply.
Well, I am not going to detail. I will just take your Lordship the basic point again, which I have submitted. Kindly turn to page 87, sub-rule 7, which has been relied upon by my learned friend to get his authority. In case of Chief Secretary, if the Central Executive Committee is of the opinion, not few Central Executive members. Now kindly turn to notice at page 102. There was no opinion by the Central Executive Committee to authorize him. That authority itself is illegal. In respect of other allegations, as I say, you have given charge sheet, I have replied, let it be gone into. But how can you hold a meeting to do all these things? Therefore, the decision ought to have been the Central Executive Committee, but the notice says some Central Executive Committee members. Now, that is the more fundamental area on which I just point out. And factual aspect, when I am not really going into those facts, that will be decided later on by the appropriate court. But if my learned junior wants to place some facts, I can place information.
My lord. Yes.
Subject to
What do you want to say?
Subject to leave of my.
We are giving you leave, yes.
That is, my lord, what my learned senior friend
Come to the point.
That is 92/7. That is at page 87.
Yes.
Page 87.
What is your point?
Page 87. In case of Chief Secretary, if the Central Executive Committee is of the opinion that the Chief Secretary has committed any act prejudicial to the interest of the union or brought disrepute to the union, the Deputy Chief Secretary so authorized by the Central Executive Committee, which will refer. But first, if the Central Committee is of the opinion comes.
That is what Mr. Bhattacharya says.
Central Committee is of the opinion means my learned senior says that the sum of the Central Committee Central Committee members made allegation and given notice, but the opinion means Central Executive Committee sitting and unanimous opinion, that is by the majority or whatever. That meeting has been convened by issuing the notice dated 14/10, my lord. That meeting should be done by the chief secretary. And if the chief secretary is unable to convene that meeting, my learned senior submitted that 75 attracted. My lord, if I am the chief secretary, before the learned court, trial court, they have submitted the rule 52 is attracted because of vacancy. How the deputy chief secretary convened the meeting, claiming himself the acting chief secretary, according to rule 52, my lord. The learned subordinate court referred the rule 52. What the rule 52 says, my lord? My lord, your lordship may kindly have a look, page. It is required to be looked into, and that's why, my lord. Page 71. 52.
Who referred to the rule 52?
They referred.
In any of these documents?
Before, yes, before the trial court, that is, trial court has taken into consideration.
Look at rule 52. What about the other rules? Even if rule 52 is not applicable.
Rule 52, if the rule 52 is not applicable, deputy chief secretary has no power to convene the meeting. 14. Deputy chief secretary convened the meeting of Central Executive Committee meeting, wherein the deputy chief secretary is not a member of the Central Executive Committee. Number one. And perpetual wrong, what are those perpetual wrong? In those meeting, my lord, conducted on 23rd/10, quorum was not constituted. Number three, my lord, the acting chief secretary, that is the Pankaj Kaushik, that is the subsequent, but that resolution has not been communicated to me. The acting chief secretary, the entire Delhi circle has been superseded first.
Let us pass our order. The present challenge has been preferred by the plaintiff in a suit whereby the plaintiff, being the chief secretary of the respondent number 2 staff association, has assailed a notice dated October 14, 2025, issued by the defendant stroke respondent number 1, who is the deputy chief secretary, calling for a meeting of the Central Executive Committee of the said association and consequential action. In the said suit, an injunction, a temporary injunction and ad interim injunction in similar terms was sought, inter alia, restraining the defendants from acting on the impugned notice and all subsequent steps taken in consequence thereof. The learned trial judge having refused such ad interim order at the ex parte stage, the present appeal has been preferred.
Not at the ex parte stage, we were present.
Sorry. At the ex parte stage, ad interim stage, the present appeal has been referred. Next para, learned senior counsel appearing for the plaintiff stroke appellant contends primarily that the deputy chief secretary had no authority under the rules and regulations of the association. These are the articles. Under the rules and constitution of the association to convene such meeting. It is contended that the authority to convene such meetings is vested exclusively in the chief secretary. Next para, in support of his contentions, learned senior counsel places reliance in particular on Rule 70 within bracket Roman II, whereby the chief secretary is to convene all meetings of the Central Committee stroke Central Executive Committee stroke Central Disciplinary Action Committee stroke Central Grievance Committee stroke General Council and record the minutes of the meetings. Next para, learned senior counsel further places reliance on Rule 75, as per clause small I within bracket of which the chief secretary may convene a special general council and circle general secretary may convene a special circle general council to deal with matters considered to be of special importance in the interest of the union when they consider necessary or on a requisition made in writing by at least 51% of the total number of electoral college EC capital of the General Council stroke Circle General Council as the case may be under the circumstances as specified therein. Full stop. Next para. Conspicuously, it is argued, conspicuously, comma, it is argued, comma, clause small ii of Rule 75 provides that in case of non-compliance of a valid requisition mentioned in Rule 75 within bracket small I, therein above, within 1 month from the date of its receipt by the Chief Secretary stroke General Secretary of the concerned circle, comma, as the case may be, comma, the requisitioned shall have the right to convene such a special meeting of the General Council stroke Circle General Council by themselves, announcing the time, comma, date, comma, etc. of the meeting. Full stop. Next para. Thus, comma, it is argued that even if there is a grievance against the Chief Secretary himself stroke herself, comma, the members of the association have a right under Rule 75 within bracket small ii to convene a requisition meeting and take appropriate steps consequent thereto. Full stop. However, comma, in the present case, comma, no option was given to the plaintiff stroke chief secretary to have the right of refusal to convene a meeting upon being so approached to do. Full stop. Next para. Thus, comma, in the absence of such request and denial on the part of the chief secretary stroke plaintiff, comma, the notice dated October 14, 2025 and subsequent consequential action is dehors the regulations of the association itself. Full stop. Next para. Learned Senior Counsel further points out that although in the impugned order it is recorded that the plaintiff had requested after the refusal of ad interim injunction that the defendants be requested not to act on the same, comma, act on the impugned notice, comma, and an assurance being given that the same would be done, comma, the defendants went ahead with the meeting scheduled by virtue of the impugned notice dated October 14, 2025, and in fact, comma, have subsequently removed the plaintiff as chief secretary. Full stop. Next para. Learned Senior Counsel places reliance on division bench judgment of this court in the matter of Indian Cable Company Limited versus Srimati Sumitra Chakraborty, reported at AIR 1985 Cal 248 for the proposition that in such circumstances, comma, the court has the power to restore the subject matter of a LIS to its original position by granting status quo ante, comma, if necessary by granting the relief sought in the main suit itself. Full stop. Next para. While controverting the above arguments, comma, Learned Senior Counsel appearing for the defendant stroke respondents contends that Rule 75 is not the only scenario under which a meeting can be convened by some person other than the chief secretary within the four corners of the regulations. Full stop. Next para. Learned Senior Counsel relies on clause Roman 7 within bracket of Rule 92, which contemplates that if there is an allegation that the chief secretary has done any act prejudicial to the interest of the union or brought disrepute to the union, comma, it may be proposed to initiate a disciplinary action against him. Full stop. Next para. Although the main provision, that is Rule 92, provides that if in the opinion of the president or the chief secretary, any of the subordinate office bearers mentioned therein are guilty of such prejudicial act, comma, the procedure laid down therein shall be followed, comma, clause Roman 7 within bracket carves out an exception where such allegations are against the chief secretary himself, comma, in which case, comma, if the Central Executive Committee সব caps এগুলো, is of the opinion that the chief secretary has committed any act prejudicial to the interest of the union, U capital, or brought disrepute to the union, comma, the deputy chief secretary is so authorized by Central Executive Committee, which will refer the matter to the Central Disciplinary Action Committee, which will, comma, in turn, comma, authorize any office bearer as a substitute of chief secretary to draw stroke frame charges and issue the charge sheet and adopt the procedure to be followed in the other cases of the office bearers in the Central Disciplinary Action Committee. Full stop. Next para, placing and drawing the attention of the court to the impugned notice dated October 14, 2025, comma, learned senior counsel for the respondents submits that it is clearly mentioned therein that on the request of the Central Executive Committee members, comma, such notice was being given. Full stop. Even the agenda, comma, it is pointed out, comma, is covered by Rule 92 within bracket Roman 7. Full stop. As such, comma, the action taken against the plaintiff, comma, it is argued, comma, was well within the four corners of the regulations of the association. Full stop. Next para, learned senior counsel next points out that in the suit and the injunction application, comma, not only the notice dated October 14, 2025, but also subsequent action taken pursuant thereto has been impugned. Full stop. Next para, learned senior counsel places before the court a charge sheet dated October 27, 2025, comma, which was also a part of the injunction application filed by the plaintiff stroke appellant in the trial court, comma, that such a charge sheet has been issued by one Pankaj Kaushik, comma, designated as acting chief secretary by the Central Executive Committee within the contemplation of Rule 92 within bracket Roman 7. Full stop. Next para, it is argued that the suit is bad for non-joinder of the said Sri Pankaj Kaushik, comma, against whom allegations have also been leveled in the plaint itself. Full stop. By way of reference, comma, learned senior counsel for the respondents places reliance on paragraph 2 within brackets Roman 8 V triple I and Roman 10, where specific allegations have been leveled against the said Pankaj Kaushik. Roman 9 করে দেবেন, 8 টা 9 হবে, 9 আর 10. Full stop. Next para. Apart from the ground of non-joinder, comma, learned senior counsel adds that subsequent action taken in pursuance of the impugned notice, comma, culminating in the removal of the chief secretary, the removal of the plaintiff from the post of chief secretary and basic membership of the association, having not been challenged in the suit by way of an amendment, comma, although considered by the learned trial judge in the impugned order, comma, the present relief has been rendered infructuous and cannot be pursued. Full stop. Next para. Thus, comma, the argument of grant of status quo ante, comma, it is submitted, comma, is not backed by appropriate reliefs having been sought by way of amendment in the suit or a subsequent injunction application having been filed. Full stop. Next para. Lastly, comma, learned senior counsel argues that admittedly the plaintiff is due for superannuation as an employee of the state bank. Full stop. Next para. Learned senior counsel places reliance on the relevant provision of the rules of the regulations, that is regulation rule 8 within bracket small I, which provides that a member ceases CEASES to be an employee of the bank shall not continue to be such member. Full stop. Clause small II of Rule 8 also provides that none but a regular member of the union other than the chief patron will be allowed to hold a post in each committee consisting of central, circle and unit committees. Full stop. Next para. Thus, it is submitted that the suit, by its very nature, is on the verge of being rendered infructuous in any event, since the plaintiff cannot continue in the post of chief secretary or otherwise after his superannuation. Full stop. Next para. On a careful consideration of the arguments of the parties and the regulations of the defendant number 2 association placed before us, we find substance in the contention of the defendant stroke respondents. Full stop. Next para. Even apart from the provision of requisition meeting contemplated in Rule 75 within bracket small ii, Rule 92 clearly envisages situations where specific allegations are made against office bearers which of any act prejudicial to the interest of the union or which bring disrepute to the union, for the purpose of initiating disciplinary action. Full stop. Although such power is vested in the president and the chief secretary in respect of subordinate office bearers, for obvious reasons, clause Roman 7 of Rule 92 provides that if the allegation is against the chief secretary himself stroke herself, in the event the central executive committee is of the opinion that such offense has been committed by the chief secretary, the deputy chief secretary is to be authorized, can be authorized by the central executive committee, which will refer the matter to the central disciplinary action committee for authorization of any office bearer as a substitute of chief secretary for the limited purpose of drawing stroke framing charges and issuing charge sheet. Full stop. Next para. In the present case, even going by the prima facie case made out in the plaint and the injunction application, which is the standard yardstick at the ad interim stage, we find that the impugn notice dated October 14, 2025 categorically refers to a request by the Central Executive Committee members upon which purportedly such notice was being given for holding Central Executive Committee meeting by the Deputy Chief Secretary. Full stop. Next para. The agenda of the said meeting clearly refers to disciplinary action proposed against the plaintiff, who is the chief secretary. Full stop. Thus, the said notice comes squarely within the purview of clause Roman 7 of Rule 92 of the regulations of the association, and there is no palpable lack of authority on the part of the deputy secretary, as per the statements made in the impugn notice itself, for the purpose of issuance of such notice. Full stop. Whether the background allegations necessitating such notice are true and stroke or the Central Executive Committee members actually conferred such power on the defendant number 1, the Deputy Chief Secretary Chandan Das, for holding such meeting are questions, are matters of trial to be decided on evidence in the suit itself and cannot be gone into at this stage. Full stop. What the court has to ascertain is whether the learned trial judge accepted one of the plausible views which is possible from the materials before the said court. Full stop. We find sufficient reason to back up the refusal of the ad interim injunction on the basis of the impugn notice dated October 14, 2025 in that regard. Full stop. That apart, another prima facie valid question has been raised by the defendants as to whether, in view of the nature of the relief sought in the suit, which is not restricted to the notice dated October 14, 2025, but also subsequent consequential action, the author of the charge sheet dated October 27, 2025, issued in consequence thereof, that is one Pankaj Kaushik, the acting chief secretary purportedly appointed for such purpose by the chief executive committee, under the provisions of Rule 92 within bracket Roman 7 ought to have been implemented as a party, and whether the non-joiner of the said person renders the suit bad for non-joiner of necessary parties. Full stop. The other objection raised by the respondents is whether, in the absence of any challenge to the subsequent action by amendment to the plaint, the further relief of status quo ante and or reliefs in the nature of restoration of the parties to the original position is concerned, comma, we are not much convinced on such argument at this stage. Full stop. It is well settled that in the event the defendants take some action to alter the status quo as prevalent on the date of filing of the suit so as to affect the outcome of the same at the final hearing, comma, the court may very well consider under certain circumstances as to whether to grant mandatory injunction or status quo ante to restore the position of the lease, position of the parties to the date of institution of the lease. Full stop. Be that as it may, comma, such proposition is not attracted in the present case in view of our above observations. Full stop. Next para, as to the superannuation, as to the impending superannuation of the plaintiff on November 30, 2025 is concerned, comma, we desist from making any comment thereon, comma, since it would be premature to make such comment, although there is only barely a week left for such superannuation. Full stop. Next para, in view of the above, comma, we are of the opinion that the impugned order of the learned trial judge, comma, who adopted one of the plausible views on the premise of the materials before the said court, comma, ought not to be interfered with. Full stop. Accordingly, FMAT 465 of 2025 is dismissed on contest. Consequentially, Can 1 of 2025 is also dismissed. There shall be no orders to cost. Full stop. We make it abundantly clear that none of the above observations or the observations made in the order impugned herein shall be of conclusive nature and or binding on the parties and or the learned trial judge while deciding finally the injunction application and or any other interlocutory application and stroke or deciding the suit on its own merits independently. Thank you. Arjun certified. Next. Thank you. Yes.
Yes. Item number 20, your lordship on 18th of this month had directed me to serve. My lord, my service is not complete. My lord, kindly grants me a week's time. On 18th of this month, your lordship had directed me.
Are you enjoying an interim order?
No interim. No interim.
So keep it next monthly list, means next week.
Not on the supplementary list.
No. Learned counsel for the petitioner submits that service has not yet been completed and accordingly seeks an adjournment. Full stop. Hence, let the matter stand adjourned for the week and be listed in the next monthly list. Thank you.
Item number 21.
21, my lord, I will be praying for time, my lord, for filing supplementary affidavit because certain documents of my lord Thika's record.
Why do you
is
mention the
required to
matter
be
then?
annexed. My lord, the
should have been prepared with the supplementary affidavit.
Unfortunately, we thought that it would be there. My lord, the order is there. The certified copy of the order is there, but certain findings and other records we are yet to receive.
Order before your lordship is the order passed under section 5. Condonation not allowed.
Why not allowed?
12
But
years.
Unfortunately,
12 years.
2012, I purchased the property.
Why supplementary affidavit?
Lord, the records are required, Lord, just to indicate, Lord, what were the state of affairs.
It's pending for quite some time.
Yes, Lord, that is there, but
Discovered before
unfortunately, we
this.
could not
It
get.
was filed on 4th of September.
Yes, it was
mentioned,
filed on 4th of September.
not mentioned, automatically affidavit.
Yes.
But my lord, subject to your lordship's correction, if supplementary affidavit comes for the first time before your lordships, then
new documents can
learned tribunal, my lord, did not have had the occasion to
Lord,
deal
the
with. So
records
then
were there.
it has to be remanded back.
The records
God
were
no.
there.
Records were there.
The records of the records before the Thika office of the Thika controller, that was there before the
Yes,
tribunal.
Mr. Khalif, what do you say? The record-
Telena's application was the subject matter. Whatever averments and records and annexures are there. So tribunal had.
Why would you want to bring the records? We
I'll
are
tell
only
you,
to see
Lordship,
the
to
section
tell
5
you,
average.
Lordship,
Yes.
gist. I'll tell you, Lordship.
Had the occasion to deal with only those.
2010, I purchased the property. I apply for mutation.
No, we need not go into the records. We'll go only by the section 5 application, whatever provision, the condonation application.
For that section 5 application, your Lordship has
So no issue. If he wants to then remand it back, let the learned tribunal be given a chance to adjudicate, look afresh upon those documents and decide section 5. If so, no, Lordship.
He'll be jumping to that proposal.
I don't know, my lord, but Lordship, how can here it will be allowed? How can it be allowed here?
Trying to bring forward the records which were before the tribunal. Nothing more than that.
No,
I cannot.
All right.
This goes out of the list. We'll come back up in the monthly list of January. You do that in the meantime. We want to bring the records.
No, that.
But we'll make it clear this pendency of this will not create any bar on any.
No, there is nothing. My application has been dismissed.
Section 5 means
in
when.
effect, my
It
application.
was in connection with what?
I tell you, Lordship.
No, not tell you. What is the main relief sought in?
The main relief sought is challenging a particular order, declaring a property to be thika. Not challenging that, we were already before the tribunal in 2012. But unfortunately, neither the order nor the proceedings were given, recorded in the order in the other proceeding, in the 2012 proceeding. Unfortunately, my lord, this order should have been a part of that proceeding by a supplementary affidavit or amendment could have sufficed. The wrong advice.
What was held previously in that
But
2012?
it's pending. As on date, that proceeding is pending.
Another application.
Wrong advice. That gentleman challenges this order afresh. The court finds that I had knowledge.
No.
Let us affirm the order. We'll record your submission and we'll say you are not proceeding with this.
If I
Mr. Kormakar, your section 5 has been rejected. So therefore, this application, this fresh application challenge is non-honest in the eye of law.
The fresh application challenge has been dismissed on the ground of section 5. That
only for
been condoned.
As time barred.
Yes.
As time barred. Only on that ground.
From the record I will display, I will demonstrate with your lordship it was not.
So, Mr. Kormakar, subject to hearing Mr. Gali, we may say that this is your submission.
My lord.
So, even if this application has been dismissed as time barred, does that prevent you from prosecuting a previous proceeding if it is pending?
He was indeed given the chance. My lord, 2012 proceeding is pending. In that 2012 proceeding, my lord, the thika record was directed to be placed before the learned tribunal. He took a search of that. Upon taking a search, my lord, he found that yes, certain things are to be included for proper adjudication of that.
No, I thought the first time I came to know
the
this order.
All right.
2019.
So, my lord, liberty was given to file a supplementary affidavit. Now, my lord, he prepares a supplementary affidavit. Now, when supplementary affidavit was taken before the chamber of a learned senior, it is averment. It is in averment. He says, at the time of settling, I find that this will not be suffice for filing in the form of supplementary affidavit. You should go for filing a fresh OA. Hence, on the advice, we go for filing a fresh OA in the year 2022.
And naturally, my lord,
Supplementary.
2010 order.
No new materials can be brought, Mr. Kormakar. On the whatever is there, you argue the matter. Why the supplementary affidavit? What records would you bring?
No, records with
If that was not there in your section 5, we cannot.
Not whatever is
there in your section 5, we'll go by that.
Whatever was there affirmed before the tribunal, I will put that on record. Nothing more than that.
No. Whatever has been filed before the tribunal is only the condonation no condonation application. Sorry.
Condonation application is there. That has been dismissed.
So then you look at that only.
Application has been dismissed.
If a condonation application has been dismissed, we look into that condonation application and their objection. Nothing else. Why should you look into the records?
I understand.
We cannot broaden the scope here. No. We cannot broaden the scope. You argue on the whatever is there. Whatever is there. Cannot bring on new records in tribunal application.
Not kindly comes.
What sort of records you are trying to bring in?
Not the records which were there before the thika control, as affirmed, which we had already.
That stage was not even reached because section.
Yes. No,
please let him ask him to stop. It's very irritating. Why didn't you have a conference? Please have your conference and then move the matter.
I'm sorry.
It's
I
a
apologize.
lot of continuous disturbance.
I
mean, it's very irritating for the court. Mr. Kormakar, either you are not ready or you are ready. If you are ready, move the matter yourself. Why lean on a crutch? Now here your application for condonation of delay in preferring an OA has been rejected, that condonation application.
Right.
So therefore, if that condonation was allowed and the OA was taken up, then we could have looked into the records which are a part of the ticker controller, those proceedings. Since it has been rejected at the threshold by dismissing or the limitation application, how can you look into the records?
By rejecting, the court, but the tribunal comes to certain findings, not to not demonstrate that those findings are not correct or as per the record. That's why you
He referred to the records.
Yes.
Show us one or two pages.
Not kindly.
Or one or two places.
496 is the.
Refer to the internal page.
Yes.
We have the order handy.
Not kindly comes to page 8, internal page 8.
Yes.
Learned advocate appearing, before taking to these points, may I just give a short brief facts of the case? 2010, I purchased the property. After purchase, I apply for mutation before the corporation. While seeing the updates, I find that the Thika controller's name is appearing suddenly. Whereas I had checked, conducted searches and found my title was clear.
You purchased what? The entire property?
The entire property, the property. Now, when it was found that, I tried to search for the records, I could not find, neither any proceedings were disclosed. I approached in 2012 before the LRTT, saying, on the prayers, my prayers were that the proceedings initiated by the Thika controller be stalled, and if any order has been passed, that may be disclosed or that may be stayed for the time being, and those proceeding itself was challenged. That was not proceeding. In that 2012 tribunal matter, there the the tribunal passed repeated orders directing the state to disclose whatever the proceedings were. Finally, in 2019, the records were produced before the tribunal. In 2019, for the first time, I come to know after taking inspection that an order was passed in June 2010 where the property was declared to be a Thika. Now, the cause of action arose for the first time for me to challenge that by virtue of that inspection in 2019. Immediately thereafter, the COVID intervened. So, I came up before the learned tribunal in 2021 and prayed for a time to bring those facts on supplementary affidavit. The nature of 2012 proceeding was good enough to convert this entire thing to be a challenge of that 2010 order of Thika controller. Unfortunately, without doing that, a fresh, according to advice given by a learned advocate, a new OA application was filed.
When?
In 2022. This arising out of which I am for your lordship. 22, 13 December 22. In 2022.
No, but you came to know about those that order in 2019.
2019.
So how do you explain these 3 years?
Thereafter the COVID was there. 2019
COVID was not there.
2019 December I came to know. Immediately
Up to March,
thereafter,
what were you doing?
February I obtained the certified copy of the order.
All right.
February I obtained the order. And thereafter your lordship knows what happened. And on the reopening in 2021, I approached and sought for time to file a supplementary affidavit so that I could challenge that order. Instead of doing that, a fresh OA was filed.
No, you were not given that liberty.
I had filed that.
You are given the liberty to file a supplementary.
Use the supplementary affidavit. Yes. Yes.
So how do you explain that from 21 to
no,
when did you file this new one?
December 2022.
So what were you doing for 1 year?
December 22 it was filed.
Supplementary affidavit you are given leave in 2021.
2021.
So at least for 1 year you are sitting idle.
Till May 2022, I will have the benefit of
not after having approached the court in 2021 during COVID.
Yes.
Not having, if you did not do so, we would have given you the benefit.
No, the difficulty is
the time is extended. But time is not extended because time is to be extended only for because you approach the tribunal.
I follow what is following for you.
That logic is not applicable.
I follow what is following. But unfortunately, because of that wrong advice, the substantive right will go.
So what are you now wanting to produce before us?
Not the records that Thika was never produced. That order or those things were never produced.
Those you want to produce now. What is the use of producing in connection with this matter?
Section
Those can be produced if we allow this.
in section 5, the court proceeds on the basis that not first it's 12 years.
But these are admitted facts on which the court proceeds.
Admitted.
So why do you record the records?
So the unfortunate, those were things I wanted to place with your lordship. Nothing
Whatever
more
is
than that.
there is discussed in this order was on the basis of your pleadings only.
Yes, yes.
So you admit
And
these facts.
whatever there is materials on
Material. So they are not disputing that.
But
You have
difficult.
challenged.
It's
So whatever
only
is
for your
there,
lordship's perusal, my lord, I wanted to discuss.
we need not peruse. We would record to peruse it if this section 5 was allowed and the main tribunal application was taken up, original application. Then only those records would be vital.
Very.
Not necessary.
Lord, in
If
that
you
case-
refer to that and those are referred in turn in the impugned order, that is sufficient. Tribunal does not disbelieve you.
Lord, it takes a different route, my lord, in
Whatever
disposing-
route, but tribunal does not disbelieve the facts that this happened. Not about maybe regarding your bona fides may have disbelieved, but these basic rudimentary facts that this in 2021 you have pleaded that you have come to know for the
record of the
exactly
tribunal
then.
itself.
So why do you require the Thika controller records? We don't require those. Let us move the matter. Yes.
Now, my lord, kindly takes the decision from the decision onwards, internal page number 8 of the order.
Yes.
Learned advocate appearing for the appellant has submitted the challenging the letter dated such and such issued by the controller to assessor such and such.
But my lord, opposition by the state, reply by the petitioner have not been annexed to this petition. State used on affidavit to the section 5, and my learned friend also used on reply to that too.
These have not been annexed.
These are not part of these pleadings. I have checked, not annexed. State used OA and you used AR also to the section 5.
Then we require those also.
Now only those two documents may be placed on supplementary affidavit.
LRTT records.
No, record.
No, you can produce copies of those opposition and reply.
Yes,
If
that
you
we
also have
also do.
Mr. Agali, you can also produce and give
You just give me those copies and copies to my lords also. Later.
Yes, opposition reply are required. Learned counsel for the petitioner at the outset seeks to use a supplementary affidavit to bring on record certain documents in respect of the main Thika controller proceedings from which the tribunal application arose, comma, in connection with which a condonation application has been dismissed, comma, giving rise to the present writ petition. Next para, however, comma, learned senior government advocate opposes the same by submitting that since the entire periphery of the present challenge is the dismissal of a condonation application, comma, such records might not be necessary at this stage. First of, we completely agree with the submission of learned senior government advocate inasmuch as in the event the condonation application were to be allowed and the main original application challenging the Thika controller's order holding the property to be a Thika tenancy was to be looked into, comma, the documents and records of the Thika controller might have been relevant. Full stop. However, comma, for the purpose of consideration of the condonation application, comma, it is only the said application, comma, the opposition and reply in respect thereof, and at best the original application itself are relevant. Full stop. Since the opposition and reply in respect of the condonation application are not before this court, comma, the petitioner is directed to file a supplementary affidavit annexing only those documents, comma, which are part of the pleadings in respect of the condonation application before the tribunal. Full stop. Such supplementary affidavit shall be filed within a week from date.
10 days, my lord, gives us 10.
Only those copies have to be annexed.
Only copies handover will do. Lordship will not.
Yeah.
You can hand over copies.
Lordship, just hand over the copies and copies to my lords also.
7 days, a week.
Within a week from now, within December 1, 2025, full stop. An advance copy of the same shall be handed over to the learned advocate for the state, stroke respondent. Full stop. The matter shall be listed next under the same heading on December 8, 2025. Right. Next. ছোট ম্যাটার হলে শোনো না অনেক সময় খুচরো হয় Yes, Vishal.
22-23. Otherwise, I am ready. I am not that, my lord. I one time that I am not ready.
But
the thing is this, my lord. It was filed, my lord, possibly 2 weeks before. But when I, my lord, this brief, my lord, I have been entrusted to go through. My lord, it appears that 2 or 3 documents which are the records of the, my lord, the tribunal, ticket tenancy controller. Now, my lord, the ticket tenancy controllers, those, my lord, papers have not been, my lord, produced before the tribunal and neither before you. This is a very, very, my lord, necessary because of the fact whole thing depends upon the, my lord, the lease deed. The
if
lease
those are not produced in the tribunal also,
tribunal before
then Mr. Sen, it will be a order for Rule 27 situation.
before the before the ticket tenancy controller.
Then you file a regular application under order for Rule 27, annexing those documents, because you need leave to produce those documents at this stage.
Yes.
And they'll be able to entitled to. So you're not enjoying any interim order here.
No, there is no interim order.
No scope. So we'll grant them leave to file on.
If you could have shown me the documents,
the document may
subject to
I tell.
satisfying your
If you
lordship
agree,
that it is necessary,
if you agree,
then
then
I may agree. Then I may agree, because otherwise,
very
your
well,
lordship-
very well, very well. That will be
let them cut short. They'll cut it short.
Document
On
may
the face of it, my lord, we are not ticketed. On the face, I can
no,
show.
if those
Yeah,
documents,
document
if those documents you don't oppose, we can exercise 27 1B.
B,
My lord,
necessary for judgment.
My lord, the person who claimed that
Session, do this. You exchange those copies of those documents with Mr.
Today, I will come back tomorrow. No
Do
difference.
you have those documents?
Yes.
So you can make a set of copies and hand over to Mr. Banerjee.
Yes.
And if he agrees, he will take 1 day to go through those and take instruction. By the end of this week, by day after tomorrow, he will be
Yes,
indicating
I'll be
you whether he agrees. If all of you agree, you take out further copies for the judges, and we'll keep it on Tuesday. Monday is the monthly list.
Monday. Yes.
Monday is the monthly list, so we'll keep it on Tuesday.
Yes, Tuesday.
Tuesday. Fair.
ঠিক আছে, এটা কপি করে
Learned additional government pleader submits that the appellants seek to produce certain vital documents which might have bearing on the adjudication of the present LIS, although those were not produced before any of the forums below. Full of next para. Learned
But these
senior.
are the part of the records of the, my lord, the ticket tenancy controller.
However, those were parts of the records. Those were part of the records of the before the ticket tenancy controller. So next para, learned senior counsel appearing for the respondent. Respondent number 1 or what?
Yes, sir, I am respondent number. In the first one, I am respondent number
1 to 6.
1 to 6.
8. আর তারপরটা
You are the private respondents. Appearing for the private respondents submits that if advance copies of those documents can be handed over to him, he can ascertain as to whether the private respondents have any objection to production thereof. Next para, accordingly, the appellants are requested to hand over copies of the relevant documents on which they want to rely on to the learned advocate for the private respondents as well as the KMC. Next para, the respondents shall ascertain as to whether they have any objection to production of such documents before this court. Such objection or otherwise would be intimated to the learned advocates for the appellants by the end of this week. In the event there is no objection on the part of the respondents, the appellants shall prepare 2 sets of the said documents for the use of court and file the same at the next hearing. Let the matter be listed next on December 2, 2025.
Okay. ওটা পরে জেনে নিও না। আরে ওনাকে দিয়ে দিও না।
দুটো সেট আছে 1 to 6 একটা 8 একজন প্রাইভেট রেসপন্স।
আচ্ছা একটা সেট ওনাকেই দাও না।
এক সেট
We are escaping, you resolve between yourselves. Do you have a full court? So we'll
কথা বলতে
আমার ওখানে 1 to 6 এর
আমার সঙ্গে বিকেলে বসো।
একটা দিন
আমাকে একটাই দিয়ে দেন।